Yeah, that's true. Yep. Two different deals.
On what? No, it's not on. No. No, it is not.
I think you just got another. Maybe
There you go. How do you think you'll go? You can have a seat wherever you like. Okay. What case did you say? Brandon?
Morning. Better not deserve.
All right, well, I'll take it.
Oh, I'm sorry. Oh, okay.
Bet you it's 30. I bet you it's 30.
Bet you 30. Because he's coming from Orlando.
JC? You got this, right?
I'm gonna get.
Yeah. I knew y'all were fluttering, so I didn't think y'all had a chance to look at that. I'm glad you CC'd me on it.
Yeah, right. According to the email, that she just was CC'd from Christian. It is now 9:30.
Oh,
9:37 according to
Oh.
GPS. I'm gonna tell him again.
well, to ask if people want to go get a couple.
Good morning, y'all. We just got
impressed that you made it at exactly the time you said you were going to, like.
Well, that's what my
Yeah.
GPS said, but,
9:37.
anyways, I'll explain. Good morning, everyone. The time is 9:37 or so a.m. First of all, I apologize for the delay. I'm Christian Watt, the Special Master for Code Compliance. There was not one but two accidents on the way, so I blame the Florida drivers, but I'm sorry. So we have an agenda for these meetings. I'm going to try and accelerate this a little bit. The first item on the agenda is the call to order. We had that. The second item on the agenda is the pledge to the flag, so I'd like to ask you to join me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all.
Good morning. If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
Okay, the next item on the agenda is the minutes from the prior hearing in November. I've reviewed the minutes. Are there any proposed objections, modifications, or otherwise to the minutes as currently formulated? Okay, I don't hear any, so I'm going to approve them.
Staff update, abated, and continued cases are listed out front.
All right. So I'm going to give you a brief statement that explains a little bit about this hearing, and I'd like to ask for your attention. Again, my name is Christian Waugh. I am the Special Master for Code Compliance here. I'm a licensed Florida attorney acting in that capacity, and what it means is Citrus County has hired me to preside over this hearing. When your case is called, I'd like to ask you to please come forward, and you will be placed under oath. If you are appearing at a hearing like this for the first time, the county will call its case, and I will allow the county to present its case first. You will have an opportunity to cross-examine any of the county's witnesses, and then you will have an opportunity to present your case regarding the violation. That will be your opportunity to present evidence and to make legal argument. It's important that you take your time during this process because it is likely going to be your only chance to make your case to me. I will also ask at the beginning whether or not you are contesting the violation. If you do not contest that a violation has occurred, we will assume that a factual basis for the violation exists, and I will ask you how much time you need to fix the violation or to work with the county to abate the violation. This will help save time for yourself and others. In other words, when you come up, if you're not arguing that there's a case and you know that there's a violation, we can just move forward to determine how much time is necessary or that I'll grant to fix the violation. You are by no means required to do so. If you want to be heard, if you want to present your case, absolutely, I invite you to do so. At any time during the hearing, I may have questions of parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak, and if there are, such members of the public will have an opportunity to speak in each case. Such right to speak is not unlimited, and public comment should be focused on the case and made as succinctly as possible. Although persons may be upset or even passionate about what they have to say, all witness testimony must remain civil, and you must not interrupt other witnesses, parties, or attorneys. In most instances, if you are found guilty of a violation, the law requires that you be given a time to comply before a fine begins. You must fix the violation by that date, or the fine will accrue for each day that you remain in violation. The law allows Citrus County to impose the fine as a lien on your property. The county has a right to foreclose on that lien or seek a money judgment against you after the lien has been recorded for 3 months. I encourage anyone here who has questions about their rights or remedies to seek their own legal counsel. In all cases in which I find that a violation has occurred, I will impose all costs required by county law. I incorporate this into all of my orders as standard provisions. If you bring your property back into compliance during the time that I allow, that cost will remain minimal. But if you do not timely fix the violation, you'll be responsible for additional costs. Although it's only happened a few times in my years as a special master, I may continue your case if I find a need for further evidence or argument. You do have the right to appeal any order that I make today as provided by law. Thank you.
First case on today's agenda, Diane Lee, case number 2024-1428. Code Licensing Compliance Officer Keith Gardner, page 30 of your agenda. Experts on the case, Certified Building Official Samuel Costa, and Land Development Director Joanna Katu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name for the record.
Noel Leon Hatcher.
Thank you, sir.
All right. Good morning.
Good morning.
Good morning.
Keith
And-
Garner,
This is page 30 of the agenda?
Yes, sir.
Mr. Hatcher, are you an owner? What's your relationship to,
She's my wife, and I'm owner on the trust with her.
okay, thank you very much.
Keith Garner, Citrus County Licensing Compliance, case number CE 2024-1428. Chapter 18, Article 1, Section 18-8A, obtain after-the-fact permits for all construction or modification, Citrus County Code of Ordinances. Address is 1294 North Circle Drive in Crystal River. Diane Lee and Noel Leon Hatcher. Good service via posting at the property in Lecanto Government Building. And I would like to authenticate the following documents and request they amended into evidence. Exhibit A, photos taken during the initial inspection, August 9th, 2024. Follow-up photos, September 10th, 2024. Photos taken during my corrective action inspection on November 21st, 2024. Photos from the property appraiser site dated December 9th, 2021. And photo from my final inspection on December 17th, 2024. Exhibit B, a copy of the notice of violation, and copy of the notice of hearing, pre-hearing order, and a copy of the posting affidavit signed, and photos of the hearing notice posted at the property. I don't believe he's contesting that there's a violation,
Well, so
so
let me ask you, and I'll hear from you straight. Are you contesting whether or not there's a violation here?
No, I'm not. We're just asking for extra time.
Okay, and how much time do you think you need to fix whatever this is?
I believe 90 days would take care of it.
All right, what's the actual issue at hand? Can you-
excuse
yeah.
me, the gazebo was built and not permitted.
It's a gazebo.
Correct.
What's it?
It was on an existing deck that was built up from the deck, and the deck is permitted, but the gazebo is
Oh,
not.
I see. Has
Just a-
anything been submitted thus far regarding the gazebo?
Something was submitted, yes. and he's
Have you had a
working on
chance to do a preliminary review, determine sufficiency?
it. It's on the water, so there were I'm sorry. The expert witness in the case, Sam Acosta, and Deputy Growth Management Director Joanna Katu.
It did have a submittal. It finally came in complete December 2nd, so it's going through the process. Right now, site and building and flood review have all denied it. As of December 11th, they are fixable. I think all of them are things he can fix, but not yet.
Well, so the real reason I'm asking these questions is because I'm just worried about 90 days. Is it?
Can I say one thing?
Yeah.
A couple things. I did start this process right after I was notified of it. And in September the 22nd, I come in and did a notary to finalize my application for the permit. And I did it with a lady named Jennifer.
Okay.
And when she submitted, when I did this, I had to come in and do a notary and stuff. And when she put it into the system, she told me I was all good to go. I would hear something in a couple of weeks. And when I didn't hear anything, I didn't feel anything about it, because 5 days later, there's a hurricane here. And I thought everything was just in turmoil. But then in December, I got a letter saying that I hadn't done that. So we were on the West Coast on vacation. We had to come back, and we went in as soon as we got home to try to correct it, and we did. We filed. And we're just in not knowing what to do right now, because we have what we think we have for records, and they have what they have. But we'll try to correct it as soon as possible. We're asking for the 90 days because it's the holidays, and we are going to be out of town for the holidays.
Yeah, I'm not debating that. What I'm worried about with the 90 days is that it may not be enough time. In other words, I don't know how long these processes necessarily take. I'm not asking law enforcement to go out and tase you or anything. So that's very rare that we have to do that. at any rate, and they wouldn't listen to me. So 90 day, I mean, I feel like that probably is a sufficient amount of time for a gazebo, even with these denials, in order to get it fixed. I mean, do you have any reason to believe that's not a reasonable amount of time to give?
I do not.
Okay, all right, what's the county's recommendation?
Recommendation is $50 a day along with administrative cost to begin after the date you deem sufficient to abate the violation.
Is there anyone from the public who wants to be heard on this case? I don't see anybody. All right, then I'm going to determine that a violation exists on the property and grant you 90 days from today to abate the violation. If it's not brought into compliance as ordered, there will be a fine of $50 a day. And, you know, that's the lowest that the county really goes in its recommendations. So that's it.
All right, thank you. I appreciate
Thank
all
you.
you guys' help.
Next case. Next case, Fred A. and Susan B. Carr. Case number 2024-1697. Code Officer Alan Jonason, page 7 of your agenda. Expert on the case, Land Development Director Joanna Katu.
Ma'am? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
Susan Carr.
Thank you.
Good morning.
Morning.
Good morning, Alan Jonason, Citrus County Code Compliance Officer. This is case number 2024-01697, Citrus County Land Development Code, section 414002.
Mr. Jennison, I am just gonna, because this is my fault, but I just want to ask you, Ms. Carr, are you contesting whether or not a violation has occurred on the property?
Yes.
Okay, all right, then please proceed, Mr. Jennison.
Sure. Site development without a development order or permit. The address of the violation is 1716 East Bismarck Street, Hernando, Florida. Property owners are Carr Fred A. Jr. and Carr Susan B. This property is .96 acres, was purchased 21 April 2021, and is zoned LDR. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 24 September 2024, an aerial photo from the property appraiser's website dated 6 May 2024, and photos from my final inspection on 17 December 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail receipt, a copy of the pre-hearing notice, and a copy of the PA. Property appraisal.
All right, so ma'am, what I'd like to ask you to do is take a look at the documents that Mr. Jonason just described and take your time doing so. Let me know if you have any objections to them being evidence in this hearing.
They're photographs. I mean, it's hard to object.
Well, I mean, let me just,
It is
and this will apply for everyone. I mean, you have the right to make an objection. They may be photographs, but maybe they're, I mean, I've never seen this at one of our hearings, but maybe you have a basis to believe they weren't in fact taken by Mr. Jonason, or they're fraudulent, AI generated in some way. But if you don't have a reason to believe that, then you don't have to object.
Correct. In fact, I live in Mount Dora, and I still work, though be it from home, so I don't understand commuting issues anymore. But I have not been back to my property since an original meeting with the individual that did this work back in May or June.
Well, we'll get into that.
So-
It's just before I can get into what your case or defenses are, I have to first understand what they're saying.
Right.
And I don't without seeing these documents.
Sure.
So can you just
Take
review
a
them
look.
and let me know if
Sure.
you object to them being evidence?
Not at this time, no.
Okay, all right.
mean,
Then
like
I
a-
will go ahead and admit them as exhibits A and B. And I'll just let the county continue to explain what their case is here.
On 25 September 2024, I conducted my initial inspection and observed the property to be in violation. On 31 October 2024, a notice of violation was issued for site development without a development order or permit, which is a violation of the ordinance mentioned earlier. On 14 November 2024, I conducted research with no permits issued. As of my final inspection on 17 December 2024, the property remains in violation, and I have had contact with the property owner. Expert witness is Joanna Coutu from Land Development.
Okay.
And the site is just under, sorry, Joanna Coutu, site just under an acre in size. It's low-density residential. It should be vacant. We have no permits. In 2021, someone applied for a house permit, never got issued, expired in 2022. That's the only action we have permitting-wise.
So a permit was not issued?
Never issued, right. Applied for, never
This may
issued.
sound like a dumb question, but if it wasn't issued, how can it expire?
Okay, technically, yes. It just pulls, it goes away.
The application and
Right,
everything?
right.
Okay.
The application
Okay.
itself expires.
Gotcha. All right. All right, so, Ms. Carr, I think I understand the situation. It appears that what their case is that there's been some modification here without proper either site plan review or permit, and from the photos, that's the way it looks. So can you tell me what's happening?
What's happening is, again, I live in Mount Dora, and the property was purchased in '21. And my husband was alive at that time, right? He passed away March 17th of '22. It had been our dream to move over here, and his health issues and whatnot didn't allow us to move forward at that time. I was going to, I don't remember, I don't believe it was me or myself and my husband that applied for any building permit. I'm not sure what that application was about. I was not informed of it if it was done on my behalf, because we were in conversation with the builder. So the first order of business, the builder passes away that August. Then my husband passed away, and I'm like, oh, God, what's going on here? So I had wanted to continue and move over, but I couldn't afford the current interest rates. So in talking to friends in the area and in general, it was, well, let's do what's possible. I had been in contact with whatever the 352 number was that got me over to answer the question of what is required to clear underbrush and the small stuff. There's no permit required. Are you sure? Yes. I probably called a dozen times over at least a 1-year period. So I contacted Citrus, what's the name of this company? Citrus Land Clearing. Calls himself Citrus Custom Grading LLC, Lorenzo Carducci, and met with him. He had been referred to me. He had done other work in the area. He'd been referred to me and said he'd been working here for, I believe, a minimum of 5 years and doing just the very thing that I had spoken with him about, which was, per what I had been told by the county office people, to clear the brush, all trees up to 4 inches in diameter, and any dead and diseased trees to clear them out of there. And he said, oh, I know exactly what it is. I built my own house in Citrus County. I do this for other people. I know exactly what's required and what I'm able to do. And I kept repeating over, and I don't know how many times I would have said it to him. I didn't know I had to count them. Don't do anything more than what is allowed in my current situation, because I do not have a building to permit. I don't have a house plan to approve and submit for permit. I wouldn't be ready anyway financially, even if the permit was submitted to do. And he said, not a problem. I know exactly what's allowed. With that, he went and did this. As I said, I work. I was not here at the time. And any photos or conversation he might have had with me would have been an after the fact of what he did and said, is this okay? My personal goal would have been, in actuality, to clear the whole lot, because it had been originally based on the ages of the trees, and I do have a history of agriculture in that my degree in college was in agriculture, so I have some knowledge. And we did not. And I kept saying to him, I wish I could, but I know I can't. Do what we can now so I can minimize any cost when I'm ready. And okay, not a problem. Then he submits this. Like I said, I did not make any trips over here because I work. And I think we had a hurricane or something in the middle there too anyway. So that's what was presented to me. Then sometime, and relative to site development. So it's not a site development, it was just a clearing of the scrub underneath. Then I get the first letter of notification from,
I mean, I'll just interrupt you right on that point. I mean, it seems really clear from the photos that this is not just underbrush removal.
he did take, there's a bunch of scrub small trees in there, and all the small trees do have canopies. So they are going to be removed from any aerial photograph. And I can only go based on what I contracted with him to do, what I requested, what I was made aware of by the county, which he told me that he was very much aware of what was going on in the county. In fact, he had just left that property, and within a month or so was working on another.
So there's a difference
Property.
in the code between what kind of trees you're able to remove and take down, and
Correct.
yes, there is a size limitation. In other words, owners have the right to take down certainly diseased trees.
Right.
Although they want you to get a certified an arborist to certify that. But this is a separate code section that talks about development. And so with that this is clearly development insofar as there's been clearing of a site. And so that's the way the code reads. So I'm trying to understand why this isn't development under this code section.
I'm just a travel agent, and I don't
Yeah.
make a lot of money, and I can't even afford to go on the cruises that I book.
When you got notified
So-
with this, did you talk to the
I did.
company that cleared?
Absolutely,
Okay.
I did. I called them up and I said, Lorenzo, you told me you knew what you were doing. If you did, she wouldn't have been able to turn it in as a quote-unquote code violation. Oh, somebody else, okay. It's a code violation. And he said, I didn't do any more than I was allowed to. And I said, well, according to them, you did. As I mentioned, I put my trust in an individual that is a professional with a licensed company in Citrus County to do Citrus County work that he has done previously. And I have no reason to believe that any of his prior properties that he'd done of this nature had been violated.
Well, so
And-
on that aspect, I mean, I think it's important that whoever you hire and rely on, you should retain your own legal counsel to advise you, first of all, just because
I tried to.
Because I can't be your lawyer.
Right.
So to the extent that you suffer in any way because of his
Right.
actions, really, they may be liable to you. But this is the kind of case where the county will request a fine, and I will assess a fine based on there's no permit.
I don't mean to interrupt, but just to follow it up with, it said building permit or site development. So, doing my due diligence as best I can with hitting brick walls every time I go anywhere, called county back and said, I've been saying I'm happy to complete a permit. I don't know which permit. I'm counting on you people to let me know. And there was a woman from Mr. Jonason's department that answered the phone one day. She pulled the pictures up, and I asked her that very question: how do I get a permit? What is how do I do this? She said, well, I have no idea. So I didn't get any help from the department. All they want to do is, say what I did and present it to you. But they don't know how to help anybody. So I got through to somebody else, and I said, well, what about a site development? What do you have to do for site development? It's like, well, isn't a site development because you're not going to be building anything. So I was not allowed any way to remedy the situation.
There is no remedy because.
Correct.
Yeah, I mean, it's.
So I mean, I tried. I didn't know what to do. I couldn't get any answers, and this is over the period of a year and a half.
Right.
And I just, it's like, well, okay, fine. Here I'm.
So what is the county asking for here?
So just to elaborate.
Yeah.
Every time she has called, we've referred her to the building division. There isn't anything code can do to help a homeowner, a property owner, with a situation like this. It's all building. Building has to inform them, hey, you need to get a permit, put a structure on it, et cetera, et cetera. So she's right in part of that aspect, but the other aspect is we can't help her. There's nothing we can tell her other than contact the building division.
But I had done that.
I'm sorry, ma'am. So.
I'm sorry.
I did, I do want to hear from the county. So what is the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $5,000 as well as the administrative cost to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation as well as the severity and irreversible and irreparable damage caused by the violation.
Can Ms. Carr receive a permit or any kind of a development order without a plan to establish a principal use?
No, she was advised correctly that you cannot get a tree removal permit. You have to have a permit for some kind of principal development, which is, in this case, probably a residence.
Okay, does that make sense?
Yes, but no, not where I'm from. I mean, this is the first time I've ever hit this kind of an issue.
Yeah.
And I'm lived in Vermont for 20-plus years and
Well, listen,
upstate
I
New
gotta
York.
tell you,
and
we do things a little differently in
Yeah, no
Florida than they
kidding.
do in Vermont.
Well-
But here's my point to you is, I think in the vast majority of counties in Florida, this is exactly what you're going to find, which is that a permit's not going to be issued for just one, like clearing alone without
Right.
the intent to establish a principal use. So when you come to the county, again, I encourage you to retain legal counsel. You can't rely on things I say. I'm a lawyer. But you're going to have a plan, and you're going to have to come in with some, and so that's what's needed before you engage in what we would call this kind of site clearing. And so I'm telling you how this is going to go. I'm going to give you a chance to respond, but I'm not going to assess a $5,000 fine. I am going to assess a fine. Before I hear from your response, I want to also know, is there anyone from the public who wants to speak on this case? Because I'd want you to be able to respond to that. All right, I don't see anyone from the public. I do want to give you the last word.
Well, I just wanted to add in that years ago, I had bought a parcel up in Marion County, vacant land. And it was 10 acres or shy of 10 acres. But anyway, in that situation, and from my non-relevant education, I actually thought, without having gone into the fire safety, the whole 9 yards, that clearing the up in Marion County, I was advised by their equivalent department of forestry and forest management that I should clear the underbrush and take out the scrub trees so that the forest can replenish itself in a healthy manner, and also the brush would reduce any chance of a spread of forest fire. So stupid me, hearing so many times a permit's not needed, trees up to 4 inches, brush underneath, you're good to go. No, there's no permit. And I thought, without reading all of the fine print in the county, records, that I was doing a good thing. And I was ultimately told, no, I wasn't. And so it was like,
Ms. Carr, I'll tell you this. I mean, honestly, these are the hardest cases that I get, just because a lot of people in your position feel the same way, and they get put. And honestly, there've been a lot of contractors out there who've given bad advice. They're happy to take the money to clear the site, but they're not
Right.
necessarily your lawyers. So here's what I'm going to do. I'm going to assess a fine. I usually do $2,500, but based on your testimony, I'll say $1,500 on this case. It's just
Appreciate
the
that.
way that it is.
It is.
I encourage you to retain counsel and
Yes.
vindicate your rights.
I will.
Okay.
Thank you.
All right, thank you.
Next case on today's agenda, Joseph M. and John Darmiento, case number 2024-1874, Code Officer Erica Olson. Page 8 of your agenda, expert on the case, Joanna Coutu, Land Development Director.
Good morning.
Good morning.
Sorry, I'm coming.
I mean, it's been a few months since I last saw y'all, right?
Yes, sir.
Okay.
Gentlemen, the other hand,
Other one.
do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please state your names.
Joseph Darmiento.
John Darmiento.
Thank you, sir. Good morning.
Good morning, Erica Olson, Citrus County Code Compliance Officer. This is case number CE 2024-01874, accumulation of junk and debris. Sorry, this is a storage case. What's the?
3102, storage on vacant.
3102, storage on vacant. I apologize for that. The address is 6107 West Homosassa Trail. Property owners are Joseph M. and John Darmiento. I have good service via signed certified mail return receipt. This property is listed as vacant. It's 0.61 acres and is zoned low-density residential. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on October 24th, 2024. An additional inspection on October 28th, 2024. A corrective action inspection on November 4th, 2024. And my final inspection yesterday, December 17th, 2024. Exhibit B, a copy of the notice of violation, copy of the notice of hearing, a copy of the signed certified mail return receipt, and a copy of the general pre-hearing order.
So, sirs, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence.
I object to everything. They were trespassing.
Yeah, I wonder how they get these pictures when I have a no trespassing offense, and why are they always on my properties? Every property I have, they chase me around town and code compliance me and everything they can.
Is this a different property than one we've talked about before?
Yes, sir,
Okay.
yes, sir.
Well,
And
then I'll construe that as an objection based on the Constitution, and I'll ask her questions about it.
Yeah, because we have a fence, we have a gate, and, you know, they shouldn't be they're on all my properties. They
They just come right on. They just
do whatever
walk
they
right
want.
through.
But yeah,
Open
these
the
are
gate,
pictures
go
of our
in.
properties, yes, sir.
All right, then I'm reserving ruling on their admissibility, and I'll conduct an inquiry as to how the photos were taken. All right, in order to do that, I do want to just see them so that thank you, so that I can understand. Again, I'm not admitting them into evidence at this point. All right, so you heard the objection, frankly, to the photos, which I construe as an objection that you were in a place you're not constitutionally allowed to be in order to take the photos. Can you tell me where your understanding is of where you took the photos?
Yes. So on October 24th, when I conducted my initial inspection, I actually had permission to go onto the property next door to theirs. And by accessing that property, I was able to see that there was the trailers and the animal pen, and then like some other stuff off in the
You have
distance.
pictures of both sides.
So, well, and so let me, is it your testimony, I'm looking at pages 1, 2, 3, 4 of Exhibit A, where I can see a fence in those photos.
So that is the animal enclosure.
So that's not
Or wait,
necessarily.
can I see what you're looking at? So that,
I'll just show you. Okay, so let's talk about page 1. There's a fence there.
that's the animal enclosure.
Okay, but
So I'm
it's,
standing
here's
on
my
the-
question.
Okay.
My question is it your understanding that the fence is or is not the property line?
So I do believe that animal enclosure is very close to the property line from their property to the one, if you're facing the properties. I think that fence is like really close to their property and then the property I was accessing. And I stayed on.
There's another fence on the outside, 20, 30, 40
And we'll get to that. But do you know the name of the property owner who gave you permission to be? David Dillard. All right. Please. All right, so it's your testimony that Mr. David Dillard gave you permission to be on his property and take photos of the Darmiento's property. Okay. Is that for all the photos that I have in Exhibit A?
No, sir.
All right. So you talked about October 24th. So are all the photos taken on October 24th from the neighbor's property?
Yes.
All right. Tell me about October 28th.
So because we saw that there were animals on a vacant property, we did notify animal control. We went out there on October 28th and I conducted an initial inspection. I was escorted by animal control out onto the property along with the sheriff's department for officer safety.
None of them had permission to go on that property, sir. And the property she's talking about is so
Well, sir,
far.
I definitely want to hear your
so
argument, but
far
I,
over on the left.
well, sir, let me first hear what the county has to say, and then I'll hear what y'all
Yes,
have
sir.
to
Sorry
say.
about that. Yes, sir.
So for October 28th, animal control escorted by the sheriff's office, y'all went out there.
Yes, sir.
Who notified you that they were going to the property? Was it the sheriff's office or animal control?
Well, we notified the animal control
I know.
that there were animals, and then they said they would be able to go out on the 28th.
What is your understanding of the basis for animal control's ability to go onto the property?
My understanding is that if they're doing a welfare check on the animals, that they're allowed onto the property to ensure that the animals are being properly taken care of, and that they can escort us onto the property.
Without a warrant or anything?
Correct.
Are you aware of, or was, at the time that you went onto the property, was there, were you under the impression that the animals were in danger?
Well, we wanted to make sure, mostly that they had water. It's a vacant property. There's no water on the property. So when I saw that the animals were there, I just wanted to make sure that they were being fed and taken care of. And
Is that your job?
Sir, no, really.
Oh, sorry.
No,
sorry.
that's, let me say this for everybody. And your comments should be directed to me.
Yes, sir. You're right. I was just-
Not to
You're
the
correct,
other, I know I
100%.
am, and not directed to the witnesses. It's just important because we want to try and keep it civil and,
Understood.
all right. Ms. Harrison?
Yes, Your Honor, I'm looking for the reference that you're getting at with
Yeah,
questioning.
so here's what I'm gonna do. I'm just gonna reserve a decision on the admission of the evidence based on the objection right now, because I can't overrule it. I mean, I think it's an interesting issue. I don't know if you have the right to take the photos. We'll get into their response. I think there may be a basis for October 24th, but I'm concerned about October 28th. I see some, are they pigs?
Yes, sir. It's my religion. It's all to do with my religion. I keep the pigs and we
eat 'em
Eat them
and make
not,
bacon.
Not sacrifice them, but something of that nature in our religion.
What's the religion?
I'd rather not say, and it's my own religion, you know.
He believed by raising pigs, you could, better your life and, feed people that are hungry.
Is there a name for that?
Yeah, but I don't want to get into it in here.
Well-
some people might look at me as different or something. I just don't want to.
I don't care what other people think. I
It's
mean,
our religion.
and you
I'm not-
shouldn't care.
I
I mean,
shouldn't have to.
I mean,
Some people don't eat pork and some people do. That's all there is to it.
okay, well, that makes sense.
And I think they're hindering my religion and many other things, and they're doing it very illegally. They chase me around the county, harassing me.
We've had a few hearings together.
Yeah, this is at least our
And
fourth
we go way
property.
back.
Yes, sir.
But I just haven't heard that before. So is it your argument, you believe that it's religious persecution?
I don't know what that big word means.
That they're
That means they're
prosecuting
going
you
against
because
you
of your
for that.
religion?
It could be. They could have offense against my.
Do you know what his religion is?
I have no idea. So
They don't care.
Who knows?
Well, it's hard to persecute someone for their religion if you don't know what their
Yeah,
religion is. So,
They could say they don't know, or
Yeah.
they don't.
like,
You just,
All right. So here's what I'm going to do. I'm just going to reserve on Exhibit A for now. We'll get into your response on what her argument is for when she wasn't on the property.
Can I say one more thing?
Are all the, well, I can't really get to y'all until I hear what
All
they
right.
have. Please proceed with your case.
during this inspection in reference to October 28th, I was able to see the extent of the garbage, the junk and the debris, the extent of the burn pit, and just how many pigs were on the property. During this inspection, John Darmiento arrived and was advised why everyone was out there and that he could not have anything on a vacant property, which he stated that he knew, and that is why he keeps relocating everything from one property to another whenever he receives notices from us. During this conversation, he was also advised that he could not burn on the property. On the 4th of November 2024, a corrective action inspection.
Let me
was-
ask you about November 4th.
Okay.
Did you go onto their property, or did you stay off the property at that inspection?
On November 4th, when
Yes.
I had to go onto the property.
And what was the basis for your entry onto the property at that time?
They were burning, and we called the fire department to come put out the fire, and fire escorted us onto the property.
Okay. You observed burning going on?
Correct.
Okay, please proceed.
Upon arriving to the property, I could see that there was a fire burning through the trees, and where the gate was, the fire department was called on scene to put the fire out, and they escorted us onto the property. During this inspection, the property looked the same as the previous inspection. While leaving the property, Joseph Darmiento drove by and proceeded to turn around and follow us down West Homosassa Trail. The driver, Darmiento Joseph, was tailgating, honking, trying to pass us, and throwing his hands up and out the window. We did try and make a last-minute turn down South Michigan Boulevard to try and lose him, but Darmiento turned into the oncoming traffic lane and then fell behind us again. We were able to turn left onto Stonebrook Drive, and Darmiento turned around. When I returned from the office, Darmiento Joseph called, and I was able to speak to him. He did identify himself as the man that was driving the truck, and he stated that he was trying to get our attention to talk to us regarding the timeline that he had to abate. He also had questions about our process and stated that he would just put his properties in other people's names so that he would not be considered a repeat. And he could continue to move the junk and the animals from one property to another. On December 17th, 2024, I conducted my final inspection from the road, not onto the property, and could see that the property did remain in violation.
Wait.
Let me
Let him
ask,
talk.
yeah,
Okay.
what did you hear that you disagreed with?
She puts in the paper that I'm chasing her down the road. Like
It sounded like a high-speed
yeah,
chase.
like I'm trying to kill her or something. I'm just trying to get her attention and see what the problem is.
Okay, so that, you were trying to get
And
her
then I
attention.
seen that she looked like maybe she was trying. I don't know. She acted like I was chasing her down, so I turned around before she called the cops on me and had me arrested or something. So I went back and then I called her, and I never said nothing about putting my properties in other people's names. She's making this into her story. You know what I mean? To whatever she wants it to look like, and that's not the truth. And also in the picture, she has pictures on both sides of my property, not just on the one guy's property. She has pictures on all sides of my property. And there's a fence that's 40 feet from any of that on the outside of where the road is,
And there's no law against having a campfire.
in a hole.
Well, I'll tell you this, I mean, first of all, and code compliance knows my real weakness. My weakness is animals. I love these guys. Look at these pigs,
And
they're
they're well
great.
taken care of.
They're also illegal. And so I don't, I don't know if that's, I suspect it's a part of what the county's case is. In other words, if it's a vacant parcel, you can't do anything with it. I mean, I don't know if a flagpole would violate. I know you're allowed to put fences up, right? But at least around the perimeter.
Hold on, let him talk first.
But yeah, let's get back. So what else about the county's?
You also, sir,
Yeah,
you're
go
allowed
ahead.
to camp on said properties. There's no law against camping on property you own.
Well, what's the county's position on that? I think that,
There's no way you can get that.
I mean, this isn't camping.
Right,
to
there
be
should be
clear.
no, there
but
should be
I
no
have camped there.
development.
I do camp there.
Development material change,
Let me give you a hypothetical. So if they didn't have anything else on the property except a tent, and they slept in the tent overnight, is that a violation of the code?
I'd have to research that a bit with the county attorney. It's not come up. We don't have people doing that. We have, kids sleep in the backyard sleepover, but I haven't had anybody try that, so I don't know.
It's her way of
If
saying
it wasn't an
There's no law
RV for
against
longer than
camping.
14
Not-
people.
No, I agree with you on
Not
that.
an RV, not a car, yeah, so
We
where
have
they
had
park
that.
the car if they're camping and,
You might be getting a test case soon
Yeah,
about the
no,
tent,
no.
so I'm just letting you know.
yes.
Well, look, guys, here's the reality. Regardless of how I rule on the constitutionality of some of these photos, there's going to be some that admittedly were taken from an adjacent property. And I don't think y'all are really arguing, like, there's a bunch of adorable pigs there, whether you eat them or not, I don't know what you do with them. But you're not allowed to have storage on a vacant parcel.
Yeah, we agreed to clean up, and we cleaned up most of everything else.
How much time do you need?
Well, they told me to change it to, because I asked them about getting the zoning changed, and they told me to take at least minimum of 12 months, more like 18 months to get the zoning changed. And that's,
If they give it to you.
That's if it allows, and that's a minimum of what she said of 12 to 18 months to get my zoning changed to keep my pigs. Because even when I had my zoning changed to build a house, I put a tractor there to build my house. They're still giving me problems about what I can keep. How do I build the house if I can't put a tractor there? I can't put a storage unit there. I can't even put my material there, and they're giving me more fines on this property. So how do I build the house?
And we pay thousands of dollars. I own at least 10 different pieces of property here in this county.
Well-
And we pay thousands
Yeah.
and thousands of dollars each year for
Well, they haven't
taxes
brought this.
for everybody just
they
to
have-
be here.
They haven't brought this as a repeat violation, you know, I don't think you brought it as.
They're referencing a case where they were in violation because their permit expired.
Yeah, no, I
and
know.
then it-
I mean,
but-
I know, but what I'm saying is, I think under the code, you might be able to bring this as a repeat case. You
Yes,
haven't
sir.
done that, which is honestly nice of them. They could have thrown the book at you. They haven't.
Very nice.
But what I need to know is how much time you need to.
To get the zoning change out, at least, like she said, I would at least need the 12 months.
You've got two. There's two ways to solve this. One is the zoning change, and one is getting the stuff off the property. Until you can do the zoning.
Well, there's
Well,
We
no,
can
that's not good
remove-
enough.
we
There's
can
not a
remove
zoning
everything
change to
but the
fix
pigs.
this.
So what the county's saying is a zoning change will not be permitted here.
It
So
it
what's the
won't fix,
basis?
it won't fix it.
Oh, it won't
It's
fix it.
residential. If they apply to commercial, it's not gonna still
How
allow
big is the
animals.
property?
0.6 acres.
Oh, it's 0.6.
Yeah, I don't know where the time frame is, but there's no zoning change it can go to allow the animals and there's not something it can do.
So you
Agriculture.
can't have pets on your land?
You can, but it's only certain kinds and only in certain numbers.
With a residence.
Right.
And they're not big enough even if they had a residence, because it's only 0.6 acres. They would need 2 acres to do it. So there's not a zoning that's going to allow animals by itself or animals with a residence on 0.6 acres. The zoning change won't get them there.
So you're
Well,
gonna
how
have
about
to
the
buy
one
some
down the
neighbor's
street where it's
property,
2 or
then do
3
a
acres?
zoning change, or get the stuff off the property. So that's what I'm really asking, is how much time do you need to fix this?
I need a sufficient enough time. If I gotta move all them animals, I would need at least, again, 12 months to get them in a safe place and, not, somewhere safe and to build a pen and to somewhere to house them. I got 10 or 15 pigs,
Well, honestly, I just don't think the pigs are the worst of your problem here. Maybe they are. Yeah, never mind. I take it back. Because the other stuff can kind of just.
Well,
I
we
do got
cleaned
some-
up most of all
I got
the
some
other
big
stuff.
tractor trailers there still. I still gotta move too, so they're gonna take a little bit of time of cutting them up and getting rid of them.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $300 per day, along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally to find that it is the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
What was the recommendation?
$300 a day.
Oh.
Sir, that was based on what she feels we should pay because of how she feels we reacted to what she's telling us to do. So
Yeah, I
that's-
mean, I can
that's
go up
just-
to $1,000 a day, and, there were prior special masters who would give a minimum of 300 and go up to
the last
700.
one
That's
we
not what
just-
I do.
Sir, the last one we just paid, what was it, 500 or $1,000 a day for 7 or 10 days? We got $7,000 or $10,000 from me?
Well, let me ask you this. Why is there looks like you've got some heavy equipment on the property too. I mean, what's going on?
Well, I was building right down the road, and then they gave me a big problem about having my equipment on the property that I already paid for all the fees and stuff, so I had to move it, so I wasn't getting charged $500 a day. I had to clear that property again, so every few months I gotta clear that property, or I'm getting fined by them, because they're always at every property I own.
Even though we're trying to do it
Harassing me.
legally.
Every
Even though we're
property they
doing it
harass me
legally.
at.
gonna give you a time to comply. I can't do 12 months. All right, I'm gonna give you 4 months to comply, and if you don't bring into compliance in 4 months, there'll be a $300 a day fine.
Can we do 6, sir?
I was gonna do 3, but because of the holidays, I'm giving 4.
Can't do 6?
I got some.
I
big-
won't.
Thank you, Your Honor.
Next case on the day's agenda,
That's fine.
Thank you.
Oh,
Deltona
I'm sorry,
Corporation.
actually, no, we're not done. We're not done. Is there anyone from the public that wants to be heard on this case? All right, I don't see any hands or anything. Now we're done. Thank you.
Thank you.
Next case on the day's agenda, Deltona Corporation, case number 2024-101904, Code Officer Julie Wilkinson, page 10 of your agenda, expert on the case, Land Development Director Joanna Coutu.
Sir? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please state your name.
Charles Williams.
Thank you.
Good morning, sir.
Morning.
And good morning, ma'am.
Good morning.
And I'm sorry, what page of the agenda?
10.
10, okay. And sir, are you, Mr. Williams, is it? You're a representative of Deltona Corporation?
Yes, I am.
Okay.
Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 24-01904.
And I'm sorry to interrupt, Ms. Wilkinson, so I'm doing this in every case, Mr. Williams. Are you contesting whether or not there's a violation here?
I'm actually not 100% sure.
Okay, that's fair.
Partially, yes.
No, look, in cases like that, I understand. Let's hear from the county.
Yes. Case number 24-01904, a violation of Citrus County Land Development Code, Section 4002, site development without a development order or permit. The address is 1822 North Palomar Drive, Citrus Springs, AKA 7990 North Wainwright Drive in Denellen.
You're telling me this property has 2 addresses?
Yes, so,
I am aware, I have seen this in Citrus Springs before,
Mm-hmm.
but why is that?
well, it's a block, it's a big block of multiple lots put together
Okay.
under one address.
Got it, all right.
Okay. The property owner is Deltona Corporation. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on October 30th, 2024. Photos from a corrective action inspection on November 20th, 2024. And photos from my final inspection on December 17th, 2024, as well as an aerial from the Citrus PA, that properties appraiser website, dated May 6, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a copy of the signed certified mail return receipt.
Sir, I'd like to ask you to take a look at these documents and let
Yes.
me know if you have any objection to them being evidence.
So which ones were taken on which date? Does it have it here somewhere?
So here, yeah, there's dates at the bottom and. You know, in criminal cases, people have the option upon showing indigency of having a public defender. I really think y'all should talk to the Darmientos about serving in that role maybe for members of the public who want their, representation.
We'll
Something
take it
for the
under
county to
advisement.
consider.
We'll take it under
All
advisement.
right.
Yes, these appear to be accurate, yes.
Okay. Then without objection, these documents will be introduced as evidence, as exhibits A and B. And while we're waiting, is there anyone from the public who's going to want to be heard on this case? All right, I don't see anybody. Please proceed.
Yes, sir. I conducted my initial inspection on October 30th, 2024, and observed that the property had been modified. I saw that there's a large amount of dirt removed from the property. While researching the property, I observed that there were no permits applied for or issued. I had contact with Mr. Williams from Deltona Corporation, who stated that decades ago the dirt was stockpiled there and that now they were just reclaiming the dirt. He stated that they would stop all activities on the property until the necessary permits were issued. I conducted a corrective action inspection on November 20th. I found that there appeared to be no change to the property and no permits have been applied for or issued. As of my final inspection on December 17th, 2024, no permits have been applied for. And Mr. Williams has been very polite and very easy to talk with.
Is it the county's case here that there's a bunch of stockpiled dirt and it's a violation of LDC 4002A to remove that dirt?
I will refer to Joanna Katu.
The county development is the placement of the dirt and the removal of dirt. They've turned it into a stockpile site. This came up initially because of road maintenance, because they're actually tearing up part of the roadway. They don't have an apron there because there's no development. So you can kind of see that on the aerials where they're coming out with the heavy equipment.
Could I walk you back? So I guess
Sure.
I miss or I don't understand the point about the roadway.
Right, so if the PA, I'm assuming that's one of your exhibits, right?
I see the PA shot.
Right,
It's-
the overall for all the lots, you can see where they're coming out on Citrus Springs Boulevard. And
Mhm.
that little area is what actually attracted attention more than anything else from road maintenance, because there's no apron there.
There's no apron.
There should be no development back there. The whole thing of an idea of a stockpile has to be an active construction, and they may have individual active constructions. That doesn't justify a stockpile. So there are ways
Is
to.
the stockpile a violation or
The
the
stockpile
removal or
itself
both?
and removal, both, yes. The fact that they're doing anything like relating to fill or removal of fill, both of those are not allowed on vacant property.
And I have two questions there. So, a lot of counties and municipalities regulate fill, so I understand that. But is the only regulation of the fill basically under the auspice of this code section? In other words, as development, site development?
There is a whole large half of a chapter about fill and how to treat permits, but yes, the citation itself is the development part. But then there's
Well,
actually.
in the fill portion, is there, could you have cited under the fill? I'm just saying.
Perhaps, but they're also taking it and removing it. We understand it's stockpile for active building contract sites, so this seemed to be more relevant.
But to be clear, your case is not the stocking, it's the removal.
It's both. It's the placement of the fill and the removal of the fill.
And if the stockpiling occurred, is it the county's case that the stockpiling occurred recently? Okay.
On the aerials, they show up around 2009 for the
Okay.
first time. I can see some stockpile. You can see some changes over the years, but that seems to be the first aerial where it shows up. Wasn't down there previously. So it has been, 15 some years since that started.
Okay, I mean, I appreciate that. That answers my questions. Do you understand the case that the county has?
Yes, I understand what they're stating, yes.
What's your defense?
Okay, well, yeah, the dirt was stockpiled many, many, many years ago, well before my time.
Seems undisputed.
Well before my time. And again, we were simply reclaiming that dirt. We weren't doing what we considered to be, what we thought would be under the definition of site modification, because basically when we removed the dirt, we were just taking it back to its natural state where it was when we started. I received the notice, and just let me say point blank, there was never any of our intention to violate anything. We just simply did not know that we needed a permit for this.
I told you probably heard earlier, these are the most difficult cases that come.
Yeah.
It's this section. But here's the issue for the county. If it's the county's position that the stockpiling is a violation, then isn't the removal just fixing that violation?
Perhaps if they restore it to the original condition, that would be something the county engineer has to determine. If we get a permit from them to recognize the stockpile and allow removal, developing it that way, the county engineer may be able to do something of that, addressing stormwater, addressing silt fences and whatever else might be needed. I'm out of my lane a little bit on stormwater.
Because it's certainly the case that if you have a mountain of sand and you have trucks going in, taking it out, it's usually a violation for lots of reasons. One is a fill section, another is, it could affect, I mean, honestly, it could affect a lot of grade issues, drainage, all that kind of stuff, I get that. But if the amount of sand had been less, like this is almost, I mean, this is a large stuff, I mean, I don't know if it's large, but it's not a minor hill of sand. But if it was like 10 feet, you know, or a cone that goes up 10 feet, would you have the same position?
We generally don't bring those to you because we can work with those people and work on how to remove it within the code. We usually don't have them this big, honestly.
Yeah, I mean, I think the county makes an interesting case, Mr. Williams. I've never seen this exact fact pattern, but whether people like it or not, this amount, I mean, it can only be moved by trucks, you know, as well.
Right,
And
well,
so-
that gets to the rest of what I had to say.
Oh, I'm sorry, okay.
Yeah, I mean,
Go ahead.
I have more, I'm sorry.
No, that's my fault.
So when I received the notice, I got the notice on the 12th of November. And I initially tried to contact, I did contact the Office of the Code Compliance, but I was told at that time that Ms. Wilkinson was out, which evidently was the case. She was out for the week, and that I needed to speak to her about it. So I could not get any rectification at all on, I don't even know if that's a word, but I couldn't get any resolution on what needed to happen that week. The very next week, was able to get a hold of her, explained to her what we were doing, and she said that she would need to take it up with someone above her to find out what we actually needed to resolve this. She did reply back to me and let me know that what we needed was a hauling permit. So I started inquiring to how do we get a hauling permit, because on the website I couldn't find anything for a hauling permit, quote unquote. Last week I was finally able to get that information from Mr. Bill LaFlame. He did give me that information. And they have been very cooperative. It was just a surprise to me that I was in violation of this, because from the minute I got the notice, I was trying to get this resolved. So that's the part I guess I'm contesting, is that the notice made it to me on the 12th, but I had till the 14th to come into compliance.
There's no way to bring it into
Yeah,
compliance.
there's no way I'm getting a permit in 2 days.
Well, even with a permit, that wouldn't have abated, you're not I mean, you're gonna ask for a one-time fine, correct?
Yes, the permit, the hauling permit would just allow him to continue to
Right.
take the sand.
Right.
Yeah.
So really, there was no avoiding this hearing unless
Right, okay.
you could have agreed on a fine or something ahead of time.
Okay, well, that was my only
Yeah.
point, but that was my point as far as that goes. I mean, I believe, and Ms. Wilkinson said, that I have been forthcoming and trying to get it done and trying to take care of this, so
Yeah.
we have not been derelict in this. I'm not blowing it off, to use layman's terms. So I guess at this point.
It's not your religion? It's not a part of your religion to remove the sand
No.
from the?
Well, actually, it is kind of part of my religion to not blow it off, because.
Fair enough. Good response. Well,
But yeah, so I guess at this point, I'm just asking for leniency, and I need to know if we have any recommendations on, Mr. LaFlame had told me basically that if we do a hauling permit, and I don't know for sure, are we also gonna need another permit?
Well, here's what
to-
we're here.
For the site work portion of it, or
Here's what
just
we're
the
here
hauling
today
permit, or-
on. The only issue today is the extent to which there's a violation of this code section and honestly what the penalty should be. You're gonna need to stay in touch with the county on what the next steps are and how you stay in compliance with the code, but I don't wanna keep other people waiting. The only real issue, what's the county's recommendation?
Due to the irreversible nature of this violation, the Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $5,000 along with the administrative costs. This amount was selected based on the actions of the property owner once they were advised of the violation.
I will find that a violation has occurred, and in the spirit of the prior amount for the holidays, I'll assess a $1,500 fine. It's a one-time thing. It's because of the quote-unquote irreversible nature. You can't go bring the sand back per se. Maybe you could, but then that would be a violation.
But I would need a
That would be a
permit.
violation
I would need a
too.
permit to do that, yeah.
Exactly. So in any event, that's really it. So that's the end of the hearing.
Thank
Okay,
you.
I do have another question, though. Well, to bring it into compliance, because that's part of this too, right? I have to-
No,
okay.
this
So-
is just,
so-
okay?
So we're done, and I work with the county?
Correct.
Okay. All right, well, thank you very much.
Thank you, sir.
Next case, Lorna A. Dwyer, case number 2024-1781, Code Officer Brandon Norman, page 12 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name.
Lawrence Dwyer.
Thank you.
All right, and are you an owner of the property, or?
It's me and my wife, yes.
Okay, all right, great. And are you a Celtics fan?
Celtics, unfortunately, Patriots as well.
Not unfortunate. You had 2 decades of really, and I, by the way, I was born in Massachusetts. I'm a fan myself, but times are good for you as a Celtics fan too. So, all right. Good morning.
Good morning. Officer Norman, Citrus County Code Compliance Officer. This is case number 2023-01781, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. This is for the address of 7647 South View Crest Loop in Floral City, Florida, 34436. Property owner listed as Lorna A. Dwyer. I have good service via posting at the property and looking into a government building, and I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit
Mr.
A.
Norman, I should have asked this in the beginning. Are you contesting whether a violation? No. Okay. How much time do you need to bring it into compliance?
Well, actually, like, because I just got a brand new lawnmower that actually works. And
2 weeks?
I don't know, because I already got the backyard done. I don't know if
That's the majority where the violation lies, is in the rear of the
Okay.
property.
So if I give you 2 weeks to bring it into compliance, will that be sufficient?
Oh, yeah.
All right. What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $50 a day along with administrative costs begin after the date that you deem sufficient. It was selected based on the actions of the property owners once they're advised, and it's appropriate given the severity of the violation. We also ask that the respondent's responsibility to notify code compliance once the violation has been abated and order allow for reinspection.
Is there anyone from the public who wants to be heard on this case? Okay, then I'm going to give you 14 days to bring it into compliance. If it's not brought into compliance as ordered, $50 a day. Good luck.
thank you.
Next case, Lori L. Goki, case number 2024-1860, Code Officer Cody McGuire, page 19 of your agenda.
Good morning.
Good morning.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name, ma'am.
My name is Lori L. Goki.
Thank you.
Good morning.
Morning.
Ms. Goki, are you contesting whether a violation has occurred on your property? And if you are, that's fine. I don't want to press you. I just, if you, like you saw the last case, it could be that easy. If not, we'll hear what each side has to say. No problem.
So, sir, I live in a rural area. I have this thing, so I can't hardly talk. But I live in a rural area. These people keep calling me. And we all these properties in my neighborhood are 1.25 acres, right? So my house is 80 foot off the property.
Well, ma'am, and
Off
I don't
the
want to be
off the
rude.
road.
I don't want to be rude. It's just if you have to give me an explanation, then I would first need to hear from the county and what the case is. I just wanted to know if you were contesting the case or not. So if you
Well,
are,
I'm moving out of my house. I'm selling my house, and I'm
Okay.
trying to move out.
I'll hear
where
from the
Mr.
county.
McGuire came.
Okay.
Go ahead and present your case.
Cody McGuire, Citrus County Code Compliance Officer. Case number 20241860. Accumulation of junk and debris, violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. Address is 10441 North Burgundy Point, Denellen. It's zoned CLRMH, and I thought it was only 0.27 acres. Property owner is Lori L. Goki. Good service via posting the property and posting it at the Canto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during the initial inspection on October 30th, 2024. Subsequent inspection on November 13th, 2024. Corrective action inspection on November 21st, 2024. And my final inspection conducted on December 17th, 2024. Exhibit B is a copy of the notice of violation, copy of the notice of hearing, copy of the posting affidavit, and a photo of the notice of hearing posted on the property in a pre-hearing order.
So I would like to ask you to take a look at these documents and let me know if you have any objection to them. I don't know if we're talking about the same property or not.
Yes, sir. Yes. This is your new picture. This one. So did you come yesterday?
Yes.
Okay. These seem to be, oh, more? Okay.
Any objection, ma'am?
No, sir.
Okay.
Those are, when I had a box truck in my, driveway, cause was trying to move my stuff out of my house. Cause I was under contract to be sold. My buyer got himself in trouble.
I think I understand where you're going with this. So before I hear your defense, first I'll admit these documents, exhibits A and B, as evidence.
I have my own pictures from.
Fair enough.
also.
And I also just want to know for the record, is there anyone from the public who wants to be heard on this case? I don't see anybody. Oh, okay, I got one. Well, not yet, sir. I just need to know. All right, please proceed.
Okay. On October 30th, 2024, I conducted an initial inspection and observed the property to be in violation. On November 13th, a subsequent inspection was conducted with no change to the property. A notice of violation was sent for junkyard conditions on November 14th, 2024, which is a violation of the ordinance listed above. On November 21st, 2024, I conducted a corrective action inspection and observed the property remained in violation. I've had contact with Ms. Lori on how to abate the violations. And on the first time, she told me that it was going to be done within the first 2 weeks, which is why it was a verbal. And as of my final inspection, as of yesterday, the property remains in violations with discarded furniture, cardboard boxes, and other discarded items.
Just give me a second to look through these, Ms. Goki, and then I'll want to hear from you. Mr. McGuire, would you say that there's been improvement in the past 2 months?
Yes, sir.
Okay. All right, so Ms. Goki, I would like to hear from you.
Okay, so, I'm selling my house. I've lived there for 27 years. I was the fourth person on my dead-end road, okay? And my house has been for sale for like over a year, okay? I had a big pile of, a big pile of limbs that I had pulled into my yard,
Yeah.
to burn. I work, I'm the only person that lives there. I work 40 hours a week, so I can only do it a certain time. My mom has dementia, that's why I'm selling my house, so I can move closer to her. And my daughter and my 4 grandkids, okay? So, I had the box truck there. My company let me use the box truck for a while. I moved most of my stuff out. My carport, when I lived there, I had all my toolboxes and all storage. I was told that my storage container that I have on my carport was an inside cabinet, so it couldn't be outside on my carport. Well, when you have a carport, you store how you can. I've had that cabinet for, I don't know, like 20 years. I've been there for like 27. I've had it for like 20 years. But so far, I've moved all my stuff out of my carport. But there are some things. I thought the thing said that I could cover what was on my carport with tarps. So that's what I did. I burned that big pile. But he came like 2 weeks after our a week or whatever after 2 hurricanes, 2 weeks in a row. So I might have had a piece of garbage or 2 in my yard. But those coolers that you see were staged there to be I just had got one out of my car so I could, because I only have PT Cruiser, so I could load some more stuff up and take it over. So those coolers were staged there to be loaded up and taken to my next place of residence. And I burned that big pile.
And you're allowed to do that, for a certain amount of time. You can have
Right.
things.
It just got there the day before, so.
Right.
And
so the real question is what remains? And so, Mr. McGraw, what does remain to be it does look like there's been improvement. I can see that in the photos. For example, the big couch I don't see anymore.
Correct.
What else remains to your understanding?
Everything underneath the carport.
Yeah. So those tarps are not good enough. They don't completely cover the stuff. It's just regardless of how you've done things in the past, the way the code section on this reads is that there's certain things you can have, like pots, like in other words, she can have like pots for plants.
Yeah, outdoor items are intended to be stored outdoors.
Right.
Mhm.
But there is
and that's
still,
what's on the carport.
There's some. I do see the pots.
Okay, the boxes that he's talking about, the boxes,
Yeah.
those are for my moving, for packing.
Okay.
So, am I supposed to put it in my house and while I'm living there? Because I'm still living there.
I see
and-
wooden, just discarded pallets and other like door items.
No,
It's
sir.
not just coolers. It's
Can I see what you're seeing so I can?
and also I see by the door there's
Mm-hmm.
I don't know what that is. Is that a shelf or a
By the
a
front
chair?
door?
By the front door.
It's a bench.
It's
It's
a
an
bench.
outside bench.
Okay, all right. Yeah, I mean, I'm not gonna find that pots are a violation. If they're outdoor pots, I'm not gonna find that a rake is a violation. I think an outdoor implement,
And he said those buckets that are on the carport, I mean, I need buckets for this or that.
Well,
And so I put them on the
is
carport.
it the county's position that buckets are a violation?
Stored in a four-walled and enclosed structure.
Like a garage
Mhm.
with a closed door?
Mhm.
But because the carport isn't enclosed, it's your position that the buckets shouldn't be out there.
Correct.
Where should they be?
Well, let me read the code section. This is 20-31A. Usually the code is a good place to start. Let's see.
But I am trying to get everything
All right. Let's just-
organized.
Yeah, clearly. All right, so it is unlawful for the owner or occupant of any land to permit, cause, or have thereon any accumulation of junk, debris, rubbish, and vegetative matter, except junk stored in enclosed litter receptacles or completely enclosed buildings, junk which will not fit into standard size litter receptacles and which is set out for no more than 48 hours, et cetera, et cetera. And so then when we look up the definition of what is junk, junk shall mean any abandoned property, construction and demolition debris, litter, waste materials of any kind, used or unserviceable automobile or machinery parts, used or non-functional furniture or appliances, or used and non-functional tools, equipment, and implements, but shall not include compost piles for normal personal commercial use in their proper location. So that's an interesting, I mean, when we look at that, it says used and non-functional tools. And then debris, it says, shall mean material which is stored externally, exposed to the elements, and is not otherwise completely enclosed by a walled, roofed structure, and shall include but is not limited to the following: discarded household items, inoperative machinery, appliances, refuse, rubbish, trash, or junk, scrap or discarded lumber, pipe, steel, plastic, glass, paper, cardboard, plumbing fixtures, and other building material. So yeah, I don't know that I think buckets fall into that myself. So I'm not gonna find that that's a part of it. It does look to me like there is, and I want you to see this. I mean, I want you to see. As of yesterday, because that's the last photos I've got, it looks like there's some discarded wooden items and boxes and blocks. There's definitely, those are junk. The glass blocks.
The glass blocks?
Yeah.
Those are for making, they're like those black, construction for windows.
I know what they're
or
used
whatever.
for.
Yeah.
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 They're-
So
they're-
I'm gonna take them to my other place.
You gotta enclose them. I mean, either they go to another place.
They're underneath the,
Sorry, ma'am. So either they're moved and enclosed, or they're enclosed there, but either way, they fit. I'm not finding the buckets are, I find those glass blocks do. I
So,
find,
there's another bench right there,
Mhm.
and I have them stacked underneath that bench.
no, they're not underneath it. They're close to underneath it, but they're not. I'm not
There's
trying to,
more
look,
under
for the
there.
purpose of this hearing, I
Right.
mean, they're just stacked right outside. Honestly, they're not even really, they're mostly under the carport, but they have to be enclosed. The stuff that's under the tarp that's like discarded wooden material, you may have a use for them, but in their current state, they satisfy the ordinance. That has to be cleaned up. I see, I mean, I am curious what the county's, what's the stuff under that banana box?
Under the banana box.
I'll show you. If you want to come up, I'll give you the mic. Like right, what's in the banana box, first of all? I call that, I mean, there's bananas on the box.
Right, because see, I have some boxes that I'm going to be
Yeah.
packing stuff in.
Right.
Okay, so this is just, these boards right here come off my toolboxes.
Right.
And I had a shelf in, the boards, there was a shelf in between. So I stacked them neatly.
Well, I don't doubt they have use, but
Okay.
under the code section, they're a violation. They have to be enclosed or,
I had to give the box truck back to my.
I know, that's why I'm gonna give you a time to comply. I want,
My arm broke down.
ma'am, all right, let's, if you don't mind.
But yes,
We'll talk.
I'm trying to.
I know, all right, if you would, thanks. Mr. McGuire, what's your recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $150 a day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they revised the violation. We'd also ask that the special master additionally find that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
My job is to give you time to comply. So this is not a major violation, and you've already made great improvements. So how much time do you need to fix it?
Well, I need to know what I need to do with.
That's what I've been trying to do, but you keep
Okay,
arguing
I'm sorry.
with me.
I'm not trying to argue.
These
Sorry.
boxes are a violation, the discarded doors are a violation, or tool items that you quote-unquote neatly stacked against the wall. And the things under the tarp, such as the boxes and the wood, are violation. You know, that's, I mean, almost everything in that carport, you know, needs to either be enclosed or be like a useful and usable outdoor item like those pots. It's just a matter of enclosing them or moving them to another enclosure, but in any event, getting them out of the view from the street. So how much time do you need?
Well, today I can take everything into my house today.
That would fix
Okay?
it.
But the thing is my house is still being sold. So my realtor's gonna be coming in.
I need a number. How much time? Could be weeks, months, days, but I need a number.
Hopefully my car's gonna get fixed and then, I can start hauling things away, but I can put stuff in my house today. But
Okay, I'll give you 14 days.
Okay.
And if it's not brought into compliance as ordered, $150 fine.
So what do you need me to do as far as the yard? Because I was told that, the wire spools that I use for tables in my yard, my granddaughters use them, were
Wire
construction material, but I'm an electrician and I can get those and I use them until they're garbage and then I burn them.
Yeah, they're not put in the yard. That's not acceptable.
Did you see the picture between the two chairs?
That's the end of the hearing, 14 days.
Thank you.
Okay, thank you.
Next case, Kurt A. and Deborah Mills, case number
somebody say they wanted to
2024.
say something?
Oh, I'm sorry. No, you're right, ma'am. You're right. I do want to hear from the public. That's my fault. Sir? Yeah.
No.
Sir?
Yeah, sir, if you
Sir,
wouldn't
for
mind
the
coming up to
record-
the microphone, give us your name and address.
I'm David Wilson, I'm a licensed realtor, I'm here today on a case also.
Okay.
My address is 11807 West of Bay Shore Drive, Crystal River,
Sir?
right there on the water.
Can I swear you in, please?
Oh, I'm sorry.
No, it's
Yes,
okay.
ma'am.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Anyway, on these cases that we're noticing, a lot of it's not your fault or mine, it's the actual laws were put unclear. Regular old person with a carport with a bucket sitting there shouldn't even be an issue because we're supposed to be here for safety to the public. Well, everything is your property. 99.9% is not safety to the public. I just wanted to mention that a lot of us just don't know that. You know, the average person, not even a realtor, knows that item sitting there in the carport is a code violation.
You can throw lawyers into that group too. I mean,
Oh, yeah,
it's-
we just don't know. And so I would hope that the people at code enforcement realize that a lot of us, we're not trying to be dirty or junky or whatever else, because we look at it and go, that's not junkyard debris, that's something I use at work.
Right.
That's not junkyard debris, that's a washer I'm fixing for my brother. You know,
Yeah,
that type of thing. And I just thought I should mention that, and we'll get to my case later
Yeah.
on, but that being the case, we would like to have possible, if possible, from code enforcement, what is wrong with the property, not just junkyard debris. That's such a big area. It makes you think there's a bunch of garbage bags sitting, there's rats running everywhere, and that's just not the case.
Yeah, sometimes it is the case.
Sometimes.
Actually, yeah.
I'm saying
Yeah,
usually it's not,
yeah,
'cause
right.
I got junkyard debris on my beautiful home on the water, built better than probably 90% of the homes in this county, and they told me it's gonna be destroyed in a month if I didn't, you know, it's happened to me twice. I'm
Right.
going, No, it was two trucks sitting in the yard that after the hurricane, no tags on them. They were destroyed. And then a couple of them had to buy real quick, that type of thing. Nevertheless, junkyard debris is what most of us have problem with. We just don't know a good definition of
Yeah.
that. And thought I should mention that for this poor lady right here. I lost my wife and I'm just one person. And you can only work on your place so many hours a day.
That's right.
How it is. Anyway.
Well, and that's why it's part of my job to give a reasonable time to bring it into
Yes.
compliance. And
Yes, sir.
it's also part of the reason why in the code, a fine doesn't immediately begin.
Yes.
Unless there's certain scenarios, but usually people have to, most of the cases you'll hear today started months or many months ago.
Mine did too, and I think I might have some I don't even know about. I have a post lady who says I get certified mail when I didn't get it. It happens a lot. I happened to get the one for this one last week when I got a court case.
I got mine at 8 o'clock at night. They knocked on my door. It was dark. I was like,
Thank you.
whoa.
Thank you.
Next case.
And Mr. Tron, let me just go ahead and read something. So it's actually an interesting point. What is the purpose behind the code section? So in section 19-22, it talks about purpose and intent. And it says, it is the intent of this chapter to promote, protect, and improve the health, safety, and welfare of the citizens of Citrus County, to impose administrative fines and costs to provide an equitable, expeditious, effective, and inexpensive means of enforcing the codes in unincorporated Citrus County. And, this has come up before, but the reason I wanted to read it is you have elected representatives to create these laws. And if you want to change these laws, they have to be amended with your county commission. If you don't think that they actually help preserve the health, safety, and welfare, ultimately, that's, for the county to take care of. So, but that is the end of the hearing. I appreciate the public input.
Could I show you some?
Oh,
couple
do you want to
pictures?
introduce evidence?
Yeah, I do have a couple pictures.
Well,
Ma'am, are they on your phone?
Yes, they are.
You'd have to actually leave your phone with the special master if you want to put them into evidence. You couldn't take your phone with you if you tried
Well,
to do that.
if I could
Well,
just
I'll advise.
let you
you're
see
not
them.
our attorney.
Sorry.
So what I'll tell you is, look, if you do want to introduce evidence, it is something that has to become the custody of the county. So if you want to introduce digital photos, you'd need to give me like a USB, or we'd have to take the phone. I don't think that's what you intend. So that's the situation.
It's just in reference to, like, the spools.
Whose phone is that?
That's mine, I'm sorry. My car's being worked on.
Ma'am, it's not acceptable to keep interrupting with the phone as well.
Yeah, I turned it off. I can't turn it off, but.
It's definitely not off. Yeah.
But my car's being worked on. This girl's calling me to tell me maybe it's hopefully.
Ma'am, do you have any other evidence?
But yes, sir, I do. If I could just show you this.
No, I can't because it's not admissible. I'd have to take the phone.
He was saying that, spools.
Go to the mic, if you would, ma'am. I just want to be able to hear you.
That spools are construction material or whatever. But there's restaurants that have these spools for their tables.
Yes.
Outside.
Yes, and by the
Okay.
way, we're not here on their code violations. We're here on yours.
Right, but I'm not gonna go mind somebody else's business, especially a restaurant.
Ma'am, I already determined it's a violation. The hearing is now over.
Okay.
Thank you.
And now I was gonna show you this other table spool that.
Next case on the day's agenda. Kurt A. and Deborah Mills, case number 2024-1348, Code Officer Brandon Norman, page 31 of your agenda.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name.
Deborah Males.
Thank you.
All right, Ms. Males, so I'm trying to do this every hearing. Are you contesting whether or not there's a violation?
Personally, I didn't know I had all these violations, but apparently I do.
All right, then let's hear from the county.
Certainly. Brandon Norman, Citrus County Code Compliance Officer. This is case 2024-01348, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This is for address 4235 South William Avenue, Inverness, Florida, 34452. I have good service via signed certified mail return receipt, and I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during initial inspection on July 30th, 2024. A corrective action inspection done on November 5th, 2024, and my final inspection on December 17th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return receipt.
Okay. Ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence. I mean, if you have any doubt that there's a violation, we need to go through the evidence and see if there is. Is there anyone from the public who wants to be heard on this case? Okay, thank you.
Can I just say something? These are the garbage cans that are out by my road for the garbage pickup. I just didn't know that wasn't allowed.
Well, I don't know yet. I don't know what they're
Okay.
gonna say about
I
that.
know, I was just wondering. Okay, yes, that's my yard. Oh, I'm sorry, thank you.
All right, then, without objection, I'll admit exhibits A and B as evidence. Thank you. All right, please proceed.
Certainly. On July 30th, 2024, I conducted an initial inspection for complaint of junk and debris. I observed the property to be in violation due to discarded items, appliances, and other junk and items on the property.
I'm sorry, I can't quite.
Certainly, I can wait until they finish their
Is there
conversation.
something? I don't know what's happening.
Are we okay? Everything okay?
All right, please proceed.
Thank you. I did meet with the property owner. We did discuss the violation. We talked about how to come into compliance, and I actually gave them additional time to come into compliance based on the circumstances that they had talked to me about. The property remained in violation at my corrective action inspection that I did on November 5th, 2024. That was after I gave them additional time. And then at my pre-hearing inspection done yesterday, December 17th, 2024, the property remained in violation.
You said November 5th?
November 5th.
All right, so just to be clear,
The photos.
Is this the Jonathan dating method?
Yes.
All right, okay.
So
No,
there are some of my photos, and I'll be happy to explain which ones. We got new phones during the period.
No, I
of
just want to make sure,
November.
because I was thinking it was from May.
Yeah, we
but-
didn't realize that the formatting
That's
was
fine,
off,
that's
so
fine.
I apologize.
Not a problem at all. I just want to understand it, so I didn't mean to interrupt, but. go
No,
ahead.
yeah.
Okay.
But it's not the only case you're gonna see that. It's in other ones too, so.
And so all right, so I mean, I see photos spanning quite a bit of time. I think I understand what the county's case is. Do
I
you not understand, or?
No, I understand that.
Oh, okay.
But, like I said, Kurt's name is on there, and I haven't seen my husband in 10 years, okay? This is my friend who helps me. He's been in the hospital 8 times since January, and since they came to me about the violations, most of the appliances and all that other stuff is gone. I had somebody come and remove, the junk, like all the metals and whatnot. But since August, how many times have you been in the hospital? 6 times since August. Yeah, so he's the person that helps me, and like I said, he's been in the hospital 6 times since August. And then when my neighbor initially started all this, I told her, I said it was August. I said, I'm not even supposed to be outside doing anything. My blood pressure was in the 200s, and I was advised not to be outside. He was hurt, and I told her, it's really hard to do this at this time. And when she came to me again, she goes, you know what, you just didn't get it done in enough time, but I needed help. And he advised me to call churches. I called several churches, and they said they only do disaster relief. So I was kind of by myself to do, I couldn't, so, I mean, we've gotten, several things accomplished.
Yeah.
So I just, have to.
So what remains to be done?
As of my inspection yesterday, I mean, there's still miscellaneous items around the property. What
Yep.
concerns me is now they're trimming trees and all that tree debris that is being trimmed. I just feel like they're not helping themselves out by addressing the immediate
we had-
concerns.
I see the trimming, yeah.
We had hurricane damage too, and the tree, I don't know if you drove past when the tree was all over the yard. We had several trees that fell that we had to take care of, and they were there taking the rest of the trees down.
I don't see, maybe I'm missing it, but I don't see, oh, I do see the vegetative matter. So are you saying that
I mean, technically now the trees are down and cut up, technically that would fall under the ordinance too, and that's what I'm saying. I'm afraid they're adding more to their plate before.
Oh, great.
And it's just creating more work for them when.
I had no idea.
Let's set that aside for a moment.
Because they just did that.
I mean, it's just miscellaneous stuff that's scattered
Yeah.
throughout. I mean, the stuff around the front porch, there's stuff around the
Right.
RV that's there.
Yeah, so let me tell you what I see. I mean,
I cleaned the
see
front
s-
porch.
I see
Mhm.
stuff that you can fix very quickly.
Right.
That remains.
Right.
There's like one thing on the side, there's a couple, like right in the doorway.
Right. Yeah, that's gone now. I mean,
Yeah, it doesn't look like there's
yeah.
much. But I hear the point. So when we look at the code section, the one that I read, they actually talk about vegetative matter and debris.
Right.
So what he's saying is, there's another train coming down the tracks, and it's this vegetative matter, debris that's piling up and not getting disposed of. So
Right.
here's what I'm going to say. I want to give you a time to comply. So how much time do you need to fix the very little remaining that needs to be done, in addition to getting rid of the vegetative matter? How much time?
I mean, how?
And I will want to hear from you, sir, because you said you want to be heard. Do you want to come up now? And I think we have a microphone if you.
Oh, he's fine.
Okay.
It's been difficult with him being in the
Do
hospital.
you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I will.
Please state your name.
James Mosier.
Thank you.
Ma'am, could you move the microphone so that he could, thank you, that'd be great. Thank you, sir. What would you like to say?
Okay, I've been helping her clean up the place, and I've been in and out of the hospital 6 times since we got notice there in August. And since then, because of this, my wound has gotten worse, and I have a diabetic ulcer on the side. It was the size of a quarter when it started. Now it's like this. And I'll gladly take the bandage off and show you. And then on this side, I got lymphatic fluid leaking, and it's burnt my skin.
Well, my question is, why are you helping clean anything up on this yard, given your condition?
Because he's my friend and he's the
Yeah,
person I-
her husband's been gone for 10 years, and I've been trying to help her as much as I can. I moved back from Arkansas. I moved from here to Arkansas, and then I moved back to help her out.
But he started cleaning up my property in the backyard, and then he.
And I had it looking good because her husband left her with all kinds of debris in back. I've taken load after load after load to the dump.
Wow.
And paid for it out of my own pocket to help her out. And I've been working on getting all this stuff together and getting it out. I had the machine set up, and I was gonna take them apart, and then this happened, and now I can barely walk, and it's all like snowballed on me. I had it looking good in the back, and it all snowballed
Well,
on
your
me.
health isn't worth picking
Well,
a bag up off the ground, just to be clear. But why, how much, I mean, honestly, it looks like there's been a lot of progress made. I don't feel.
I mean, the other, the stuff around isn't gonna be a problem. We can get that done
Right.
in a couple weeks. It's just, now you're saying.
And we're also trying to avoid the problem with a neighbor across the street that called and that started this thing to begin with. It's all because he's selling his house, and he feels that our house is gonna depreciate the value of his house. And so then there was a bunch of dead trees and everything, and the guys were clearing the lot next door, so I said, well, maybe the best thing that we do is get some of this stuff cleared up while we can.
So that stuff, you know, when it gets cut down, it becomes vegetative matter and debris under the code.
And it's gonna be addressed
Yeah, so it's gotta go.
immediately.
So really, my question is, how much time is it gonna take
To get the tree debris down now?
to clear the property, to bring it into compliance with the code?
It's gonna take several months anyways, because at the rate that I can move now, it's gonna take several months, because if I have one good day out there where I can work, then I pay for it by 2 days being laid out. And I mean, that's essentially what this is. It's why I'm back on a walker, because I get so I can walk without a walker, and then I go out there and work, and then I'm back on this damn thing again.
Gentleman that's supposed to come and get logs.
Yeah.
But I don't know when he's, you know, his timing, especially with the holidays and stuff too, so it's not, I mean, I didn't realize the tree debris was gonna be a problem now.
It's just, there's not, yeah, I mean, I actually agree. I think I think everything else could be handled in, honestly, hours, not days, hours.
Right, I'm just saying now if we pile the tree debris, that's where we need the time, not for all the other stuff that was in there.
You
'cause
just
all the
need,
other stuff is
you
gone.
need someone to come with a trailer and to pick it up, and that's it.
I have a trailer. But right now, it's loaded with stuff that we've already picked up in there, and I've gotta get that to the dump. And that was blocked yesterday because of them working on the trees.
All right, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests the special master assess a fine of $100 per day along with administrative costs to begin after the date that she deems sufficient to abate this violation. It was selected based on the actions of the property owners once they were advised of the violation, and it's appropriate given the severity of the violation, as well as the respondent's actions relative to the violation. We'd also ask the special master to find it's the respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow for reinspection.
I'll give 2 months. If it's not brought into compliance in 2 months, $100 a day.
Now we're talking about the tree
I am
debris?
finding that that's a violation.
Okay, cause that just happened.
I know, it's in the evidence. All right, good luck.
Next case on today's agenda, Min D. Tran and On Thu, case number 2024-1530, Code Officer Alan Jonason, page 41 of your agenda. Expert on the case, Land Development Director Joanna Katu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Your name, please.
My name is Thao Lee, and Mr. Tran, due to the health, he cannot be here, so he gave me the power of attorney to represent for him to be here to hear
You
what's
have a
going
power
on.
of attorney?
Yes, I do.
Okay, all right, then we'll get into that. Please proceed.
Yes, sir. Alan Jonason, Citrus County Code Compliance Officer. This is case number 2024-01530, Citrus County Land Development Code, Section 4002, site development without a development order or permit. The address of the violation is 10381 North Big Bass Trail, Denellen, Florida. Property owner is Tran Min D, Tran Thu An, and Tran Family Trust, dated February 23rd, 2005. This property is 14.23 acres and is zoned CLMH and was purchased on 9 July 2024. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. I'd like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 3 September 2024, and an aerial photo from the property appraiser's website from 6 May 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail receipt, a copy of the pre-hearing order, and a copy of the property appraisal.
All right, sir, I'd like to ask you to take a look at these documents and let me know if you have any objection to them. And are you, or your principal, contesting whether or not there's a violation on the property?
No, because we don't know what's going on. That's why I'm be here. Then
Gotcha.
then
That
I
makes
will
sense.
transfer the message to the Mr. Tran. Yeah.
Okay. thank you. Without objection, what's been proposed as Exhibits A and B is evidence.
No.
On 3 September 2024, I conducted my initial inspection and observed the property to be in violation. On 31 October 2024, a notice of violation was issued for site development without a development order or permit, which is a violation of the ordinance mentioned earlier. On 14 November 2024, I conducted research with no permits issued. As of my final inspection on 17 December 2024, the property remains in violation, and I have had contact with the property owner's representative. My expert witness is Joanna Coutu, Citrus County Land Development.
Okay.
And this is a little over 12 acres. It is, appears to be wetlands because it's so much wetlands. Way in the many moons ago, they were able to get a permit for a dock because they could demonstrate it was wetlands and couldn't be developed for a residence. That's part
So
of.
like the vast majority, if not all of it, is wetlands.
Right, they demonstrated to a director decades ago about that, so it's a very old dock. I've spoken to him just a little bit before the meeting too, I didn't know he was involved in this case. They aren't contesting, but, they just purchased it, so I think that would be
I
the
see.
claim.
I see, okay.
This is a
And-
realtor involved in that. so,
Okay, so there's members of the public, others involved, okay.
Yes.
How did it come, I mean, was it based on a complaint?
Yeah.
Yes.
Okay, all right.
Yes.
And is there anyone else from the public who wants to be heard on this case besides, and ma'am, you're a realtor?
No, sir, I'm a attorney, Citrus County attorney, representing myself and
Oh,
my husband,
okay,
retired.
okay, gotcha. All right, well, sir, I'd like to, do you have a copy of the power of attorney? Are you satisfied with his standing, by the way? Does the county have issue with his standing?
I have no issue unless the county attorney.
Okay, so in here, one time, I bought it for him.
Sir, did you bring a copy of the power of attorney?
Yes, I do.
I would like to see it, yeah, and I'll let the county look at it first. Sometimes the county objects, there are rules on standing at
I
these
see.
things. Okay. Let me just take a look at it. Wow, okay. So this appears to be the original.
Yes.
Okay. I'm just gonna leave it there for now, and I'd love to hear what you have to say.
Okay, so one time he bought it, and then he loved the property, and then we see the property like not maintenance, overrun, like all weed and wax, like crazy, then get to the dock. And per the county, we see the permit before, like 10 years ago, with the dock. So we allowed to maintain the dock. In order to do that, we have to pass the bridge, but the bridge on the page, they have several pieces of broken piece. Then he bring the pile of the wood, so he replace it. That's why I submit to him. And also we have several, like a pothole, then he bring the dirt to fill it up. That's what he did. And yeah, and then there are several of the tree, they fell down due to the hurricane. We have the picture. That's why he removed, he cut it. Yeah, that's why it's still in here.
Mhm.
So after that, then we get a violation. We don't know what the violation because he did not do anything besides filling the dirt. Because the pothole, he and his wife about 75 years old. That means they want to work and then make sure he not strip down. That's why we have the dirt to fill it up to make sure it's level. Then nobody can strip down. And several pieces of the bridge, they broken, so we replace it. And all of the bridge we have on the survey, they indicate the existence, so we didn't build the bridge any at all. We have the presidency here, they can assure the bridge was there. That's when we didn't build or do anything. And after that, we get a violation. We have no idea what the violation for. Yeah.
Well, I mean, wait, what is the violation for?
So the violation is, they brought in many truckloads of fill dirt. They constructed bridges without a permit, graded the site, improved the site, that that kind of stuff.
So they, in order to build the things in these photos,
Have to have a permit.
they would need a permit.
Yes, sir.
And none of this is permitted.
No, sir.
But we did not build anything at
No,
all.
I understand what you're saying. Sometimes this happens, and sometimes there aren't proper disclosures, and there's a policy issue here. I mean, I don't know exactly what's going to happen, but if a prior seller commits a violation on the property and then sells the property, and the buyer's not aware, maybe the seller even certifies that everything's good. Can the seller escape liability? Who ultimately ends up as responsible, once the property changes hands? So the code section, the code in Citrus County says that subsequent purchasers can be liable under the code. In other words, the current property owners, if there's a violation. Now, the people who actually did it could be too. So I'd love to hear from any other witnesses or people who want to be heard. So, ma'am, if you want to come up, I'd be happy to hear from you. And I guess we'll swear you in.
Hi, I'm Marie Bloom.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good morning.
Good morning. Thank you for the opportunity to speak. My name is Marie Bloom. I'm a retired Citrus County attorney. My husband, who had to leave for another appointment, is retired commander of the Citrus County Sheriff's Office. We reside at 10467 North Big Bass Trail. Our property abuts the island property that is at issue.
It must be nice. These look nice.
Oh, it is.
Yeah.
It's a wonderful location. Our property is separated from the island by a canal which is 12 to 15 feet wide and a very small lagoon. From my back porch, and you'll all be jealous, I have a full view of the island on the west side, from the existing boat dock to the road that goes from the mainland to the island. We purchased our property in 2002, and to give you a little bit of background, but I'll be concise. We purchased it in 2002, built a home, and moved in April, May of 2004. We were fortunately or unfortunately there for the 2004 hurricane season, which we had 4, I think, maybe 5, including tropical storms, at which time this property did not exist. The island was absolutely 100% engulfed. There was a small patch of dirt where the original bridge going from the mainland over to the island, which did survive that. The rest of the island was totally underwater for months. It was really, really deep. Since then, we haven't had as much trouble with flooding out there. Shortly after the date of the purchase or the transfer of the property, from my back porch, I noticed there were construction people out there on the island, and I thought, well, this is not a buildable piece of property. They're clearing some trails and paths, because this property, the original footbridges date probably 25 years ago, prior to our purchase of this property by McKay Drake, who was a developer in that area. His family owned the entire, a whole lot of property. So at that point, in June of this year, about the third week of June, the builders, the clearers, usually about 2 people, sometimes 3, would come over to the island, and they were sawing trees, they were chipping trees, they were dropping fill, they were bush hogging on a daily basis for the entire rest of the month of June, plus July, and almost all of August. No weekends, no holidays, no break, which really was a noise issue, but we won't even go there. From my back porch, I personally viewed the fill dirt being brought in. There originally was a footpath which went out to the boat dock that was built probably 10 years ago. And that footpath was cleared and bush hogged. Trees were cut, they were chipped. The property at some point, I'm assuming, prior to the transfer was surveyed, and there were red survey markers marking wetland, except for the pre-existing wooden paths, which were
Do you think there's
stationed.
any of it that's not like wetlands?
No, the entire island is. Now, that tree cutting, and I've got photos and exhibits of the things that were done. let me back up for a moment. On August 23rd, I surveyed the property and I took photos. I could see most of this from my backyard. I could see the sheds that were placed on the property. I could see the trucks coming in with the fill dirt. I could see the trees being cut. I could see the chipper. I could see and hear the bush hog. Did that multiple times throughout those periods of time. Went out there on the 23rd, took some photos, talked to a couple of the land development guys that were working on the property. You know, what are you guys planning for here? We were told that the owner was going to build a house out there, and he was very excited about it. He loved the property and had every intention, and they were clearing for the preparation for a home to be out there. I explained to them at that point that good luck, because it's going to be real wet. You can't put a septic tank out there.
Yeah, you don't really want to build on
You don't want to
wetlands.
build on
Yeah,
something that
yeah.
floats every 14 years.
Right.
Or 10 years or whatever. After that, I thought, well, maybe they'll talk, you know. I don't know if they did or not, but it continued up until August 26th when we left. We were out of the country for a month. They were still continuing to pull things down, to bring in fill dirt. They created a road out, like I said, back to the dock. They were replacing the wood on the previous established footbridges, and it appeared to me that there was actually a new footbridge all the way in the north point. It may have partially been there, I don't know, but the photos show you what I saw at that time. It's a shame that it's come to this, because it truly is a beautiful piece of property, but it's not buildable. It should have no structures on it. It was virgin territory until it was cleared and the cypress trees were cut down way over, you know, the statutory size for trees. And like I said, I have photos. I have a letter, a listing of the photos. The photos are each numbered. They're marked. They're dated on the date. I went back to the property again on September 7th, and it was continuing.
Have you shared these photos with the county?
I spoke to Mr. Jonason on 2 occasions and made him aware that I was taking photos.
Okay. Usually it's my practice to not allow the introduction of evidence from just members of the public. So to the extent that they are sought to be introduced, I allow them through a party. That's why I'm just asking. If the county wants to introduce them as evidence, it's up to the county. But in any event,
Sure.
And I want to make sure I understand your testimony. Were you the Citrus County attorney?
No.
Okay, you
I
were
was
a Citrus
I was
County
an attorney
attorney.
here in Citrus
Okay,
County.
I was going to say, are you to
retired.
blame for some of this?
No.
Okay. All right, no.
I
You might have some
retired
people to
about-
answer to.
I retired about 8 years ago.
Okay.
So I'm no longer functioning in that capacity.
Okay. Sir.
Okay, so one time we bought the property, and then before we closed the deal, we talked with the builder in the neighborhood. That means the builder only indicate we cannot build in that area. We already know. That means we're not going to develop at all.
Yeah.
Yeah, that's when we know.
No,
it's
I
not
get
really
it.
like we clear some stuff we build because we only talk with the builder. That means we're not build it. And the owner, he thinking he just clear everything so his wife can work. Then maybe in the future he will donate something. That means he's not going to build anything at all.
No, I understand. I mean, look, the issue here is, honestly, it's like undisputed from the county, the public. There's been development without a permit under the statute. And what I guess my question ultimately for the county is going to be is, I'm curious, well, I'll let you guys speak for a moment.
I walked from my backyard.
That's fine. It's like a 5-year-old. That's funny. At this time, we're not gonna put these into evidence.
Okay. So, Ms. Bloom, not to discount the value of
all right.
your work, it's just that
That's okay.
the way I view quasi-judicial hearing. Now, there's a difference if it was like a zoning, a rezoning, or something like that. You could have an intervenor status.
That's okay. Not a problem.
All right.
But I'm strictly here in support of Mr. Jonason.
I hear you.
And his findings
Okay.
in this matter. Because the last thing I want is a VBRO in my backyard.
Okay.
Thank you.
Thank you. Mr. Jonathan, is it the county's contention that the current owner is in any way responsible for the?
I cannot verify that.
Yeah. It doesn't sound like it.
Well, I will tell you this, when I was out there on September 3rd, there was construction going on. You can see in the photos.
Yeah, I see that.
There's wood, so whatever was happening was continuing on September 3rd.
When did ownership change hands?
It was 9 July.
Yes, about that
2024.
time. Yeah. So when the time he worked there, he said, "Oh my God, it's kind of nobody. I can work here because like broken pieces and then overrun." And I looked it up, the existing permit. You have to maintain the work. That's why he cleared it up. We didn't know, if we cleared up and we
You've
have
heard several, I assume you've heard the similar cases today.
Yes, yeah.
This gets a lot of folks. And the reason is to, the theory is that only upon proper county review, making sure that it satisfies things like the building code or whatever,
Yes.
that there won't be other adverse effects to neighbors and the public.
Yeah.
And honestly, even the people who are building, because sometimes there's unsafe structures out there. So I don't know if these bridges are safe or not, but this is the kind of thing that has to be reviewed by the county. So what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $10,000 along with the administrative cost to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation, as well as the severity and irreversible and irreparable damage caused by the violation.
So you'll understand my questions coming about this. The county has,
Absolutely.
the county's never asked for $10,000 before.
Right.
Why here?
Wetlands, sir. And, yeah. And
What portion of the, I'm just talking, but what portion of the property has had unpermitted development?
So I only got as far as the 1 footpath that you can see, but that property goes way back, and I did not get access to what is happening past that foot.
You don't have access?
I didn't have access afterwards. They were still building that bridge, and it wasn't really safe to cross.
I see.
So I couldn't go any further, but evidently they were adding additional bridges.
The code
past
compliant,
that.
the code compliance boat didn't get out there?
Sir, I tried.
Okay.
I tried. Unfortunately, it was being used for a fishing expedition by our director that day. So.
Ma'am, you want to be heard on this?
Certainly. Having been a property owner.
And I would ask that you come, only because we keep the record that
Having
way.
been a property owner there for over 20 years, 20-plus years, we have seen and watched that property from, like I said, my back porch. We've been on that property prior to the exchange. We entered that property through the homeowners association easement, which goes out to the original bridge, and that's how we get on that property.
There's an HOA easement?
There's an HOA boat dock easement, yes, that goes out to, and abuts that initial large bridge that goes across. That is how I walk across to the property, but we've been out there many times before. Originally, like I said, the original owner, McKay Drake, put in the original footbridges, and that was prior to our settling in that area. That was prior to 2002. He owned all that property, his family did. Those footbridges had not been maintained since they were originally put in. That property had been mowed briefly in intervals about 8 years ago. The section that went out to the boat dock that was put in 8 or 10 years ago, had grown up to be a footpath. It is now a road that goes out to the boat dock. It's been graded, it's been filled. The original bridge to the property has been repaired, which was in bad need of being repaired as a safety violation, I would propose. But they've repaired that to where you can actually walk over there without taking deep breaths.
Yes.
But all of the footbridges have been repaired. All the lumber on the top of the footbridges has all been replaced because
I mean,
it was all rotten.
Do you have a problem with that?
No, I just don't want someone living in my backyard, and I don't want someone stripping a natural resource that is a wetland, absolutely. It was underwater when we got back from being out of the country in October. We got back October 27th, and that property was totally underwater except for a pile of fill dirt that was still present. You could see through the woods and from the boat, the fill dirt that hadn't been spread yet, and except for the strip or the road path that they had put in going out to the dock where they had put all the fill, that was no longer underwater. Like I said, in 2004, when we were first there, that entire island was underwater with a small portion from the original footpath. Now, you know, this year, it was all underwater. From my backyard, I could see the main river across the island.
Can I ask Ms. Bloom a couple of questions?
Yeah, please.
Ms. Bloom, during your prior statements, you indicated that there were trees removed as well. You stated
Yes.
those were cypress trees?
Oh, yes, large cypress trees. Part of the photos that you denied entry are showing you the large chunks of cypress trees along the paths where they had cleared all the cypress trees. There's an area right there to the left as you come off the bridge that has been cleared out for a house that had massive trees in it, and it's completely gone.
When you were observing, were you able to estimate how many of those massive trees may have been taken down, either by seeing stumps or the trees remaining?
I can tell you that when I initially started hearing the property development, and that was in June, evidently before the final paperwork was signed, till the time I left the country in late September, there were folks out there with chainsaws at least 5 days a week, most of the time 7, from 7:30, 8 o'clock in the morning until after dark, every day with chainsaws, and then you heard the chipper. They'd cut a tree and then they'd chip it, and they'd cut a tree and then they'd chip it. And then the bush hog would start, you know, and then the fill dirt's come in with the truck, you know, and all of that is in violation of code.
And when you indicated you were on the HOA footpath, was the area that you saw development occurring in a small portion of the 14 acres, or did it encompass almost all of the 14 acres?
I can tell you that according to the survey that I assume his boss did with the red tape initially around everything that except for the original footpaths, I would say there's probably been, and this is just a guesstimate, probably 25–30% of the island's been cleared.
Okay.
And that's just off my head. I have nothing to base that on other than having seen the property over the years.
No further questions, Ms. Bloom.
Sir, before, you have the right to cross-examine as well, like if you
No,
have
no,
questions.
I'm not cross-exam. I just say something I want to say.
Okay, then by
that's
all
all.
means, go ahead.
Yeah, okay, so before he clear anything, then we had a survey, wetland survey. That's why we mark down. That means he know he cannot touch anything to the wetland marked down. That's the reason he clear, because he know he cannot
Well,
touch.
he can't cut it, I mean, he probably can't cut most of this without a permit
Okay.
anyways.
I don't know which, because, you know, like, based on the code, any vacant land cannot more than 4 inches. That means he know, but I don't know, he worker cut anything, I don't know until he said that.
Yeah, so this issue came up earlier, remember, you know, it's possible to remove certain trees without permission from the county, but when it rises to the level of, you know, development or clearing per se, it runs afoul of this code section.
Yeah, because, you know, when time we see, we have to maintain the way on the permit. That's what he thought, he have to maintain it. And then I told him, don't touch any wetland. That's why he get the survey of the wetland. Anything outside of the wetland would
I'm
not let him clear.
amazed that there's any portion of this that isn't wetlands or wetland setback. That would be really surprising to me.
Yeah, I have. That's why we have the
Is there
wetland
a
survey.
wetlands delineation or anything
Yes,
here?
we have the map of the wetland right here. And after that, then we have the wetland of the department come here. They said, oh, I thought it's kind of a violation, but it's okay. That's what I emailed. That's on the permit right here.
Can I
Yeah, I'll look, before I take a look at it,
Perfect, thank you.
I will consider it as evidence because whether it has a chance to help you, you know, in terms of.
Yes, yeah, that's why we asked everybody before we do. Then he said it's okay, it's not violation.
Now, besides this, do you have any other evidence that you want to introduce? And why don't you bring that to the county attorney as well?
Okay, thank you.
So normally, ma'am, I allow members of the public one chance to speak, but you've become a witness essentially for
sorry.
the county. No, so I'm not ignoring you, it's just,
That's okay.
yeah.
I just wanted to say one thing to their benefit. That when the areas were roped off and red taped from the survey that they had done appropriately, the workers, it may have been unknown to them, but the workers cut the tapes, removed the tapes, and just plowed right through the wetland portion. They did not adhere to what may or may not have been requested by the owner.
Okay.
But
I don't think that actually helps him, but.
I'm sorry. Well, he may have had good intentions.
Yeah, because the owner he should do the good stuff and then clear it up, make sure nobody can strip and then replace.
No,
That's
I get
all.
it.
Yeah.
Yeah.
So,
If I
but we didn't know yeah.
could ask the representative a quick question. Who took these photographs?
I did.
Okay. When did you take them?
I don't remember, but whatever. Maybe I can go back to my computer and track down.
In the last 6 months?
Yes, yeah, maybe like 2 or 3 months. Yeah. I
Since
think.
the hurricanes?
Yes. Yeah.
Okay. No objection to the photographs.
All right, those will be introduced as Exhibit C.
The other information is from the Florida Department of Environmental Protection. I'm not sure what the relevance of these are, but.
I don't know either. I'll take a look. All right, let me look. I'm now being presented with what appears to be an email exchange primarily dated October 16, 2024. I'm going to admit that as Exhibit D. And then a letter from the FDEP, purportedly, dated September 23rd, 2024, sent to Min Tran on behalf of the Tran Family Trust with an address in Chiliota. Let me just see this. Yeah, all right, I'll admit this as Exhibit E, and just give me a moment to review it. All right, Exhibit E notes that there was the following actions taken. Fill sand used to elevate historic access paths, additional activities including the restoration of an unpermitted historic footbridge, dredging and filling of, it says more than 0.1 acres of wetlands. It suggests that the area should be restored to the way it was, and I do see a wetlands, rough wetlands delineation. I'm really skeptical any of this is buildable.
Yeah, it's not.
It's not, yeah,
Yeah,
okay.
because we talked with the builder before we
Gotcha.
bought it, we know, yeah.
Yep, all right. Well, I've got good news and bad news. The good news is I just saved a bunch of money by switching to Geico for car insurance. No, the good.
So bad.
I know. I am gonna find that there's a violation, okay? It seems undisputed, and honestly, you've been very candid and forthright about the stuff that has happened on the property. These exhibits that you've introduced are, honestly really good evidence for the county that there's a violation, because it shows, and you haven't tried to hide it, by the way, I'm not accusing you of that. I think the question is, the county wants to, and is suggesting to me that, wetlands are, deserving of special protection. And they do have special protection under Florida law, which is why you're corresponding with the FDEP. What I'd like to ask the county is, you are allowed to do things on wetlands sometimes and get permits for things on wetlands and mitigate impacts on wetlands. Are these the kinds of activities that they might actually be able to get a permit for?
I've not looked at the letter you have, but most of them I've seen have a clause at the very end that says they do not relieve you from local government permitting that may be
I know.
required. Yeah, you can't just impact wetlands on a vacant lot. They got the dock permit, which would give them the right to clear to the dock. But it sounds like they've gone way above and beyond that.
All right, is there anyone else from the public who wants to be heard? I don't see anybody. Is there anything else you'd like to say?
Yeah, after we get this one, he said, hey, we not do anything, then we stop working, and then he remove everything. Yeah, that's when he said, this one in the future, maybe he donate to the county or someone, because he want to do good for the county. That's what he spend the money. It's not really he intend, to do anything in the future at all, because he's 76 years old, and he get like 2 times and then pass out. So that means the doctor said, you cannot drive car anymore. That's why he said, hey, now please come over here and just represent me what's going on, because I didn't know I get any violation. If that's the case, how can we help the county or something, make everyone happy? That's the key, yeah.
I have no reason to doubt that. I think that, I think y'all are trying to do it the right way, but there was activity that violates this code section. It is wetlands.
Yeah, we totally understand now. Before we didn't know, because we see the broken
I
piece of
understand.
wood. Yeah.
I am gonna issue a fine, $5,000. That's it.
Thank you.
Thank you.
Thanks.
Thank you, sir.
Okay, thank you, sir.
Thank you.
Next case, Abmel Soto Walker and Gladys Cruz, case number 2024-1546, Code Officer Alan Jonason, page 40 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Ma'am, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name for the record.
Gladys Cruz.
Thank you.
Good morning, ma'am.
Good morning, Special Master.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2024-01546. Citrus County Land Development Code, Section 4002, Site Development without a development order or permit. Address of the violation is 7043 East Channel Drive, Hernando, Florida. Property owner is Soto Walker Abamale, I hope I'm saying that right, and Cruz Gladys. This property is .53 acres and is zoned CLR and was purchased on 29 June 2020. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 3 September 2024. Photos from a compliance inspection on 17 December 2024, and an aerial photo from the property appraiser's website from 7 May 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the notice of hearing posted on the property, a copy of the posting affidavit, a copy of the pre-hearing order, and a copy of the property appraiser.
Ma'am, two things. One is I'd like to ask you to take a look at these documents and see if you have any objection to them. But number two is, are you contesting whether or not there's a violation on the property?
After knowing what I know today, it's a violation, sir.
Okay, well,
Thank you.
all right. Oh. I have this power of attorney from,
I noticed it was just for today's hearing.
it is, still, I don't want possession of it, so I don't know if you did. Oh, okay, I'm sorry. All right, exhibits A and B, do you have any objection, ma'am, to those documents?
No, what I have noticed is there are multiple pictures of the same.
Oh, yeah.
Yeah.
All right, then I'll admit exhibits A and B as evidence. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $5,000 along with the administrative cost to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation, as well as the severity and irreversible and irreparable damage caused by the violation.
This also looks like a nice property. How big is it?
A little bit more, they have
Half
an
an
acre.
Okay.
Half an acre.
It's nice.
And it's wetlands too as well.
It's wetlands.
Yes.
100%?
Yes.
Are you aware of
It's
that?
It's almost
No.
flooded now. but-
No, it was flooded, now from Milton, but we do have a survey. In the part where it was clean, it's a dry spot.
Okay. Is there anyone from the public who wants to be heard on this case? All right, then I'm going to issue a fine of $1,500. Thank you.
Okay, thank you.
Thank you. Thank you.
Next case on the day's agenda, Russell's LLC, case number 2024-1720, Code Officer Julie Wilkinson. Page 35 of your agenda, expert on the case, Land Development Director Joanna Coutu.
You're bringing them separate?
Yes, sir.
Okay. Good morning.
Morning, how you doing?
Good.
Folks?
Or afternoon.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please state your names.
John Russell.
Susan Russell.
Thank you.
Okay. All right.
Which one together?
Separate.
Hmm.
Separate address.
All right. Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 2401720, Land Development Code Section 4100, Site Improvement Plans. The address is 6986 North LeCanto Highway. The property owner is Russell's LLC. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on a, excuse me. Exhibit A, photos taken during an initial inspection on October 16th, 2024. Photos taken during a corrective action inspection on November 21st, 2024. And photos from my final inspection conducted on December 17th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a copy of the signed certified mail return receipt.
All right. Sir and ma'am, could you, I assume y'all are representatives of Russell's LLC?
Yeah, we both own it. Yes, sir.
Okay. Please take a look at these documents and let me know if you have objection to them as evidence. And normally I would ask if you're contesting the violation, but I really don't understand what the case is yet, so.
So I was gonna say, we're confused with the whole thing. I mean, once we can talk,
Yeah.
we'll go back from the beginning and how this all
Fair enough.
started.
Okay. Is there anyone from the public who wants to be heard on this case? I don't see anybody. Okay, without objection, what's been proposed as Exhibits A and B as evidence? Okay. Please proceed.
Yes. This property is a vacant commercial property, 0.35 acres and zoned to GNC. On October 16th, 2024, I conducted an initial inspection and observed a shipping container on the property. I conducted research with land development and found that the use of the property had changed from a fruit stand to a contractor's office with outdoor storage, without any change of use permitted. On October 16th, 2024, a notice of violation was issued for site improvement plans. On November 21st, 2024, a corrective action inspection was conducted, and the property remained in violation with no permits. I have had contact with the property owner and advised him of the violation. As of my final inspection on December 17, 2024, the shipping containers remain on the property and no site improvement plan has been applied or issued. I have an expert witness, Land Development Director Joanna Katu.
I just need to be walked through this a little bit.
No problem. Each site is about 0.18 acres. They're definitely next to each other. They're general commercial. Absolutely, a contractor's office with outside storage isn't allowed use. But
I'm sorry, let me just back you up. So we have another case coming.
Right.
Is that what you mean by both properties?
Each property is exactly the
This
same
one
size.
and the next
Yes,
pro-
they're next to each other and they're
Okay.
both 0.18. Sorry,
No,
I'm
it's
sorry.
okay.
So-
I need to have it explained.
Right, so one is vacant, was vacant before, it was used, whatever, it was vacant. The other one has a building and a couple parking spaces, and it was a non-conforming fruit stand many, many, many years ago and just changed hands this year. General commercial will allow the use they're proposing, but they do need to have a site improvement plan to do that. So, the building permit, the site improvement plan will look at various things, and they might be totally not in violation, but you've changed it. You've changed the occupancy type, so they'll look at bathrooms, they'll look at ADA compliance, parking, landscaping. Our code has a lot, not to scare them, our code has a concession for protecting existing commercial structures. It can give them some relief from, say, landscaping. There's nothing. That parking lot is just a big.
So this one's the vacant one.
The vacant one, yes. It's
Okay.
just vacant. Now it's used for parking and storage.
But before they can use it with its current zoning, they need to have a site improvement plan, and it needs to be, a site improvement plan is something that's approved by the county and issued by the county.
It is. It would be in conjunction with the next lot. They're clearly together.
I see.
And it's doable. I'm not saying they can't do it, but they do need to come through that, and we'll be looking at a lot of things such as access, and they've closed off access and.
And so the offending part of this is the container?
The use itself was vacant. Now, the fruit stand may have morphed into that, but they were never permitted to do so.
So I just want to make sure, but what is happening on the property that is the violation?
Yeah, so this actually came to us from the fire marshal's office because they had fenced off access, and they were concerned about getting in there. So it's the use, there's clearly some storage things going on there, and it's used as a parking area rather than a vacant commercial site.
Okay, so anything, basically.
Anything that's there, not that it can't
What about
get
the
there.
fence?
The fence itself is fine.
Okay.
They have a barbed wire on the back. It looks like they were smart enough to move that in a little bit because it abuts residential. I didn't check that, though. I think the fence was itself, other than closing it off for the fire, which there's a mechanism with the fire marshal, you work those out.
Is that a part of the site improvement plan process?
It would be part of it,
Okay.
yes.
I think I understand what's going on. What do y'all have to say?
So there's a property that's not in this. There's 6976 where our actual office is. 6976 is actually the plumbing company. 6980 and 6986. 6986 is the double lot, the size of 6980 twice. We purchased 6980 with 6976 back in February, and the one storage context that's on 6980 was used to hold painting and supplies as we fixed up that building. We got done fixing it up in May. We acquired the other 6986 property, which was a fruit stand that was condemned with like homeless people were living in.
And to be clear, that's the one we're talking about right now. The
Right, so
county-
it's empty. It's got the blue container on it that's empty, and I had it scheduled to be picked up last week, and they never made it, and they were supposed to come last night. So that container and the other container on 6980 are both getting taken off the lot. So there's gonna be nothing but nothing, just
And that would
empty.
fix the violation, correct?
Which we have the pictures of it being empty,
Empty the
but
containers, which I wanna
it should be
submit to.
picked
Well,
up
the
by the end of this
container,
week.
even having it there is a
Yes,
violation,
yes, sir.
Correct.
so. Okay, so I honestly, I think that's easy. I mean, how much time do you need to get everything? I heard what you said, by the way,
Yes, sir.
but how much time do you want?
A couple weeks just to make sure that I sold them to Sheds Galore in Crystal River. They called me last night and said the leaf springs broke on their trailer.
Okay.
So they're supposed to be out there tonight.
What is, what's the county's recommendation on this case?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We'd also ask the special master additionally to find that it is the respondent's responsibility to contact Code Compliance Division when the violation has been abated in order to allow for inspection.
Is 14 days enough?
Yes, sir.
All right, so on this case, case number 2024-01720, which is for 6986,
Yes, sir.
the old fruit stand, so to speak, I'll grant 14 days to bring into compliance. If it's not brought into compliance as ordered, $100 a day.
And
Thank you.
this means we don't have to have a site plan, right?
'Cause we're not
That is, I
building
mean, I
on
think
it.
that's correct.
Because we're not doing it.
building.
On this one. So on that one. Now we'll hear what the county has to say, I presume, about the
Yes.
next case.
Next case, Russell's LLC, case number 2024-1721, Code Officer Julie Wilkinson, page 36 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Julie Wilkinson, Citrus County Code Compliance Officer, case number 24011721, Land Development Code, Section 4100, Site Improvement Plans. The address is 6980 North Lecanto Highway. Property owner is Russell's LLC. I have good service via posting the notice of hearing at the property in the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on October 16th, 2024. Photos taken during a corrective action inspection on November 21st, 2024. And photos of my final inspection conducted on December 17th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, and a copy of the general pre-hearing order, a photo of the notice of hearing posted at the property, and a copy of the posting affidavit.
All right. Are you contesting whether there's a violation on this one too?
Yes, sir.
Okay, all right. Then I'd like to ask you to take a look at these documents and let me know if you have any objection to them.
No, just where the picture's taken from the side of the Tan Connex, all this is 6986.
Okay.
Because it's two lots. So the fence goes from 6976 all the way down to 6986. We basically fenced in all four parcels there.
Okay.
4 blocks. I mean, yeah, it's the same stuff. Yes, sir.
And is there anyone from the public who wants to be heard on this case? All right, I don't see anybody.
Can I submit the site survey plan from when we bought 6980?
So what I'll do is I'll allow the county, I
Yes,
can't,
sir.
it doesn't make sense for me to really hear your defense until I even understand
Okay.
what their case is, which I
All right.
don't yet. Okay. All right, please proceed.
This property is a vacant commercial lot, vacant commercial property, 0.35 acres in Zone G and C. On October 16, 2024, I conducted initial inspection and observed the shipping container on the property. I conducted researcher's land development and found that the use of property had changed from a fruit stand to a contractor's office with no outdoor storage or any change of use permitted. In October 16, 2024, a notice of violation was issued for site improvement plans. On November 21st, 2024, a corrective action inspection was conducted and the property remained in violation. I have had contact with the property owner and advised him of the violation. As of my final inspection on December 17, 2024, the shipping container remained on the property with no site improvement plan that has been issued or applied for. I have my expert, land development director, Joanna Cachuto.
Joanna Coutu, Land Development, also a commercial lot. They can get there from here. They just have to come through a site plan and do that, a site improvement permit.
So the way they're using the property is a permitted use?
Could be a permitted use in general commercial, absolutely. But right now, it's not.
So, a site, yeah, I guess I just want to understand. So when something's like a general commercial property and something's a permitted use, they still can't do the use until they have a site improvement plan?
Correct, correct. It can be allowed. They don't have to go through any kind of zoning changes or zoning approvals because it's allowed, but they do need to go through that improvement, the permit, the site development order. It's site improvement plan is the name. And that deals with everything. That will deal with parking, that will deal with access, that will deal with any building codes.
All right, I got it, thank you. I'm just reading the code sections real quick. I'm definitely gonna wanna hear from y'all. I just wanna read the code so that I understand what it says. I want to ask the county a question. So the title of this is site improvement. And I'm not saying this is the case here, but if all they did was put something on the property, if all they did was put a container there, is that an improvement?
Yes.
Why?
It is any kind of development. So we have the site development permit, which is on vacant land, or the site improvement permit, which is any development on improved land. And this one actually does have some improvements. There's some pavement and things there.
I know, but so when I look at section 4200, for example, I'm just going to read some language. It says site development and improvement plans only remain valid, if actual construction has not commenced within 2 years. That seems to imply to me that as part of development or improvement, there's construction. And that's why I'm asking, because if all they're doing is, what if all they had was plumbing materials or pipes or something, and what if it was pipes?
Mm-hmm.
PVC or something like that. Is that an improvement or development?
It is. It would be like bringing in a prefab shed. There's not actually construction, but we're putting something there. If I paved it, that would also be an improvement. So those are all.
I agree about pavement.
Yes.
I think that's easy.
But if I decide to store something there, like outdoor storage, even if it's a constructed building or a shed or something like that, that would be storage.
With a prefab shed, we've got 18-8A or whatever it is. and at least the county's presented cases
Right.
through that code section. And again, I'm not even sure, maybe there's other things that are easy for me to determine. I'm just trying to think, I'm also trying to anticipate their arguments without having heard them. But I guess I'm a little concerned that where does it end? In other words, you're saying that putting PVC pipes on the property is development or improvement. Maybe, is it, which one? I mean, is it improvement? Or
It
is
depends on if the property is vacant or the property is improved before you put it there.
Okay, so let's say it's improved because there does appear to be paving.
So a site improvement plan, if that's gonna be a permanent storage area, you do have to permit the storage area, yes. If this was a pod, of course, that would be like a shed, but looked upon as a shed, but we don't really frown on those, but if I wanted to do a storage area at all, and it's going to be permanent, that would need that improvement plan.
I get the intent.
Okay.
And that all makes sense. What I'm trying to get is from the point of where can I tell in the code that just by virtue of putting pipes on an improved property, they would need to have a site improvement plan? Because that's not development.
Under 4100 actually is development when you look at the definition of
Okay.
development.
Where's
It's
that?
any, chapter 1-18.
All right.
Thank you. Should be
One,
me too.
or, oh, 1 dash, is it in my LDC or is it in the?
It's in the LDC. It's chapter
one.
1, the
Okay.
definition of development,
It's
page 18.
page 18.
At least in the online version, it's page 18.
This is helpful, so I appreciate y'all's patience. Okay, let me read this. The carrying out, are we on the same, the
Yes.
carrying? All right, let's read it for the record. The carrying out of any building activity or mining operation, the making of any material change in the use or appearance of any structure or land, or the dividing of land into 3 or more parcels. So conceivably, what the county's argument here is that it is development because it's a material change in maybe the use and or appearance of the land.
Yes.
I now understand the county's argument. What do you all have to tell me?
The site survey I got when I bought the property back in February lists that as a vacant lot, number 6980. So it's not an approved lot, it's vacant. And the only thing that's on that lot besides a container is that pipe rack, and I can move that pipe rack to 6976 and there'll be nothing on the lot.
A vacant lot could be improved.
So
Okay.
originally, they had called in about the connexes.
And it was an
And,
accessory.
yeah, so then we actually have emails back and forth with the county. We actually talked to her. We came in, we came here multiple times. And the improvement plan was based on if we were we were taking the connexes off, and then we were gonna build something there so that we can put storage in it. And then that's what we thought the whole improvement plan was, if we had to build that in the pre-app meeting that we had with Citrus
With
County.
Kelly back and forth
But-
said that she was wondering if we had a site plan showing what I wanted to do in place of those storage lots. And so we were in the assumption we only needed a site plan if we were building anything on the lot or developing
And we
it.
decided
Well,
at
and
the
that's what I
time-
thought initially too,
we're not
and that's
doing
why I went through this process, and I think the county did show me to my satisfaction
Okay.
that, that is actually development. And so you need a site improvement plan.
So if I clear the lots off and don't do nothing with them, do I need the site plan? Like, the
Does
only thing
that-
that's on there is a pipe rack.
Does that abate the violation if they take everything off the property?
I don't think so, because it's still being used for parking, et cetera, so I.
Well, what if it's not used?
If it's not used, yes.
That's
If-
what I
if they-
mean.
If they take everything off and do not use it, yes, that could.
Okay.
Well, can I bring up the fact that 6976, the part of the building of 6976 that's approved, the awning borders right at 6980, so there's no way to access our building without stepping on 6980 or parking or pulling in to get into our office.
And I want to make sure, okay, so you previously owned 6976.
That's where
That was
our
our
office is.
original
If I could submit a picture and the
We
site
didn't
plan,
build that, it was
you can kind of
previously
see what I'm
there.
talking
Yeah,
about.
whatever you have. I mean, I'd ask that you show the county first.
6976 and 6980 starts at the fence right here.
So this is 6976 and this is 6980.
This
property boundary between the two of them. And so you indicated there's an asphalt driveway here.
Yeah, this one's stopped. It goes to a concrete pad that goes to the front of the building that's right here in this photo.
Okay, that's this one.
And then this driveway has a 20-foot gate that we enter this property to be able to get access to the backside of all this.
Okay, do you park on this lot at all?
We do not we park our trucks out here, but overnight they'll bring in like a trailer with a tractor or something,
Mhm.
leave it there overnight, and then in the morning they take it out.
Okay. No objection.
Okay.
Um,
I'll admit this as a, no, I'll admit the settlement statement as Exhibit C and the photo as Exhibit D. Let me just take a look at it. So what are you saying about the photo?
The photo shows the building of 6976. Right at the concrete driveway, if you flip open the settlement statement, there's a site plan from the attorney.
Mhm.
And the building on the back of it has a covered porch that goes onto 6980.
Mhm.
And it's part of like how we get into the back of the building, we have to go on 6980, so we have to use that area. And then there's a gate right there, that's a 20-foot gate that we pull in, and the guys will leave like the equipment there overnight, so that's why we fenced everything off so no one breaks in and steals it. And then they use it daily, so it's not there all day.
How long has it been used this way?
Since we bought the building, we bought it in February, we got done working at the end of May.
Yeah, it was
and
like the beginning of June
since
when we
June.
moved in, yeah.
But before it was a produce market, it was a drywall company, and then it was a plumbing company before that, so it's always been used as a construction building, or it was a produce market.
I mean, is there a permit or a site improvement plan for the building on 6976?
76. No.
That was, we didn't, I mean,
No, we
everything
just
was
went in
there.
and painted it, we didn't do anything to the structure, everything was existing. They sold produce out of it and had like the whole inside cleared out, so we just went in and painted the walls, put some new flooring down so it didn't smell like old produce, and painted the outside of it. It was already set
Yeah,
up
the
before for
parking
a
lot was all
drywall
there.
company.
Well, if you didn't have 6980, it appears that there is parking for the building.
Yeah, out in the front.
That
We
was-
Okay,
park-
okay, I'm just
We
checking.
park
Yeah.
off the road, yeah, there's pavement for
I-
each
I
space,
understand.
everything's done like it's supposed to.
You're
for
not
the
saying
building.
it's inaccessible without the 69?
No, just getting into the back of the building, you can access the whole front side of it, yes. But to get into the back of the building is why we have the gate there. And it's a vacant lot. And the only thing that's on that lot is that pipe rack and some other pipe. But I can move all that to the side of 6976 and until we can figure something out. I am working with Bo Keen, he's a civil engineer for the county, and he is going to, for 6986, draw me up some kind of site development plan for that, to put a big like 80-foot by 30-foot storage building, so that we can maybe transfer everything over to that lot and then either A, rent that out for an office or do something else with it. But he had an emergency last night at 3 a.m. and his text was to just come and tell you guys that we are working with him.
Well, here's the deal. I mean, it's regardless of how long it's been used this
Yes,
way, if it doesn't have the plan, and it violates that section where it's being used, they want a site improvement plan. Now, if you're not using it for parking, if you don't use it, if it's,
Yes, sir.
that's not gonna be a violation.
Okay.
So, you either need to get the site improvement plan, have it approved, or stop using it.
Okay.
How much time do you need to do either one of those things?
'Cause you gotta work.
I mean, you
Oh.
could stop using it until you get the site improvement plan.
Right.
So conceivably, you could stop today.
Yeah. Yeah.
But how much time do you need?
For them to draw up a site plan and everything and submit it, I'd probably need at least 30 to 60 days for the engineer. I know he's backed up.
Do you have any reason to believe that's too little time?
Yes.
Okay.
I think that probably is. I think 6 months is much more realistic for them.
Okay.
Because of the engineering involved.
I hear you, and I think that, I won't speak for the county, but it doesn't sound like there are immediate health, safety, sanitary concerns that would warrant me immediately, putting a gun to y'all's head code-wise. So what we'll do is I'll find that there's a violation and give you 6 months to bring it into compliance.
Okay.
Okay?
Yes, sir.
Thank you.
Thank you.
Oh, I'm sorry, what's the county's recommendation if it's not brought into compliance?
$100 a day.
Okay, $100 a day if after 6 months it's not brought into compliance. Thank you.
Thank you.
Good catch, Laura. Next case, Whitney Lynn Head, case number 2024-1031. Code Officer Julie Wilkinson, page 22 of your agenda.
She's already been sworn.
Okay.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name.
Whitney Lynn Head.
Thank you.
Ms. Head, are you contesting whether or not there's a violation on the property?
No, I mean, I've kind of inherited this property that I've been trying to clear off for
And how
a
much
while.
how much time would you need to bring it into compliance?
I don't, there's a couple of things, I've talked to her yesterday, there was a couple of things that I needed to keep clearing off.
Right,
If I just knew what else I have to do, I don't know,
Oh.
maybe a month, maybe a couple of weeks.
Do you have, I guess in order for me to help you with that, I would need to see the photos. Do you have any objection to the proposed exhibits here?
All right, and these were all the old pictures?
Then one's
Well,
from
keep-
yesterday or very last.
Okay. Okay.
Okay, so do you have any objection to me seeing these
No.
documents as evidence? All right, then we'll admit them. I presume exhibits A and B as evidence. And the reason I'd like to eventually I'll look, all right, it's just to help determine what amount of time should be allowed. And, I mean, just by your instinct, I mean, how much time do you think you need?
I don't know, maybe a month, because I know I have to get rid of the wood pile.
Okay. How big is this property?
I don't even know, to be honest with you.
0.41 acres.
Okay, all right. Ms. Wilkinson, is it your understanding that it's primarily the vegetative, or is it this, I mean, I do see some stuff.
Yeah, there's some stuff.
Okay. I am gonna make some findings, okay? Are the concrete blocks a part of that? Ms. Wilkinson?
Yes.
Okay. I actually agree. It looks like there's a lot of wooden debris pallets type stuff. Anything that's junk and debris has to go. I
Right.
think maybe you said at least a month, right? I
Right.
mean, okay. I think 2 months.
Okay.
What's the county's recommendation?
$150 a day.
Look, I'll give you 2 months to bring the property into compliance, and if it's not brought into compliance, $150 a day.
Okay.
Okay?
All right.
Is there anyone from the public that wants to be heard on this case? All right, that's it. Thank you.
Next case, Alex Schrein and Kayla Tremblay, case number 2024-1696, Code Officer Alan Jonason, page 37 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Your
Good
name?
afternoon.
Afternoon, how you doing?
Please-
My
please-
name's Alex Schwerian.
Okay. And sir, are you contesting whether or not there's a violation on this property?
No, I'm not.
Okay. What is the issue on this one?
Again, site clearing, cutting down trees, grading. It appears now that there's a shipping container on the property now as well.
Okay.
That I observed yesterday when I went out for my compliance inspection.
Now, that's a separate issue than what you're bringing here.
It
under-
is, that will be something that
Okay.
is addressed later.
Okay,
but-
so the issue before us is the clearing and that kind of
Yes,
stuff. Is it wetlands?
No, sir.
Okay. What's the county's recommendation?
$5,000.
I would like to see the photos. Yeah.
Can I?
Yeah.
I'm actually in the process of submitting permits. The drawings my builder submitted earlier in the week were kicked back. They needed some sort of seal. The guy who does his drawing or whatever is out of town until the end of the month. So those permits will be in very shortly. I'm not exactly sure when.
The
but-
issue with this is that apparently you did work before you got a permit. And so as a deterrent value, I basically issue fines on these cases.
Okay.
Unless I see something crazy, it's gonna sound a lot like what you've heard.
Okay.
But I'd like to look at the photos. Do you have objection? Okay.
I know
Then
what
without
it's-
objection, exhibits A and B are evidence. Is there
No.
anyone from the public who wants to be heard on this case? I don't see anyone. Let me,
And if
yeah.
it helps, it's just under an acre.
Okay, it does
Size-wise.
help. This is very similar to several of the cases that we've heard today, so it's my inclination to issue a $1,500 fine, despite the $5,000 recommendation only. And I know that these monies are going into a beautification fund now, but it is the holidays. So in any event, that's it.
Thank you.
Okay, thanks.
Thank you.
Next case, Kenneth S. and Catherine M. Smith, case number 2024-1876, Code Officer Brandon Norman, page 38 of your agenda.
Are they going into a beautification fund currently?
Board of Commissioners adopted that recommendation December the 10th.
Really? It's like days ago? Oh, wow, okay.
Good afternoon. Brandon Norman, Citrus County Code Compliance Officer. This is for case 2024-01876, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This is a repeat violation initially observed on October 29th, 2024 at 5641 South Eaton Terrace, Inverness, Florida. Property owner listed as Kenneth S. and Catherine M. Smith. I have good service via posting at the property in the Lecanto Government Building, and I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during my initial inspection on October 29th, 2024, November 22nd, 2024, December 2nd, 9, 13 of 2024, and then photos taken yesterday at the pre-hearing inspection of December 17th, 2024. Exhibit B will be a copy of the notice of hearing for a repeat violation, a copy of the posting affidavit that I completed, and photos of the posted notice of hearing for a repeat violation at the property. Exhibit C will be a findings of facts and order acknowledging compliance from previous case, and that's going to be for case 2024 00105. Do you need those dates again for the inspection dates? Okay, just to make sure.
Is there anyone from the public who wants to be heard on this case? And
You have a correction. That findings of facts was 2023 00105.
Oh, okay. I do want to try and take cases where there are people here, just FYI. All right. I'm sorry?
It's just because the public wanted to speak. I'm sorry.
There are people from the, because I thought I asked.
Yes,
Okay,
there are.
I didn't see any
Yes.
hands. Okay, no, then thank you.
Yeah, no
I
problem.
that's what I want. I'll admit exhibits A, B, and C as evidence.
On October 29th, 2024, an initial inspection was conducted of the property for junk and debris. The property was found to be in violation of the above ordinance for miscellaneous junk and debris scattered throughout the front of the property. This is a repeat violation from case CE 2023-00105, where the property was found guilty on 10/19/2023 and was brought into compliance on 11/21/2023.
What is he doing? What's going on in the front yard? I mean, I'm trying to figure it out. Was there a festival or something, or like
No clue. The property remained in violation at all my subsequent inspections, as well as the pre-hearing inspection that was conducted yesterday, December 17th, 2024. I have had contact with Mr. Smith. He has informed me that he's not happy with the state of the property and that it's occurring from his kids that are staying there. He is unfortunately in the hospital, he stated. But again, he's well aware of the ordinance as per the last case where we worked with him.
All right, let me just look through these photos and the prior findings.
I do have one more thing to add too, is the stuff is just being migrated to the back of the property. Unfortunately, because of the fence from the neighboring properties that they've had to put up so they don't have to look at this, I think today we would ask that you make Mr. Smith allow us to have access to the rear of the property to make sure he's not just stowing the things in the backyard.
Okay. This was one of my cases. I'm just kind of surprised I don't remember it. Okay, I'd love to hear from the public.
Certainly.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
All right, so one at a time, I sure would appreciate if you would announce your name and your address and tell me what you want to say.
Okay. I'm Elaine Brown.
I can't hear you.
Elaine Brown. I live at 5611, which is right next door.
Okay.
We have been putting up with this mess for a long time. And because he's such a nice man, we did not want to do anything, but it's got to the point that everything has been put out back, and you can't see that. We can see it from our home. I have pictures, but I know you can't take them, so we can see the mess. They have junk cars. They have an old camper that's rusty that is out there. They have metal objects. They have 2 trailers of garbage that's out there that we can just see from where we are. And that's not looking in or over. There's so much stuff out there. They have a pool that is just stagnant, and mosquitoes are coming from that. It is a horrible mess, and we're having to live with that. We're stressed from it. The son allows people that he knows to bring junk in, drop it off. We've seen him put old tires back there. We've seen him put this huge metal rings out there.
So what
they
you
brought in.
heard, apparently Mr. Smith told Mr. Norman that it's his son, or, primarily, and that he's maybe incapable of stopping it, but what's your is it the son?
The son has brought in a lot of stuff. When we first moved there, it was a nice place. His wife has passed away, and after she passed away, it got worse. The son and his daughter, he had a daughter there, she messed the whole inside of the home up, so they can't even live there. They had hoarding cats there. The cats are all over the neighborhood now because the animal control made them get it out of the house. Wow. The place reeks. I mean, it just reeks. And the poor man can't live in his own house. But everything the son has put out back, I think he's afraid of his son. I don't know. And the son he and his girlfriend were living in the shed out back.
Wow.
And they no longer are. They've moved somewhere. We don't know where, but they come at nighttime and they bring things in. And the backyard is horrible. It's just horrible.
and
Stinks in the summertime.
it reeks. We can't go out in our backyard in the summertime because it just reeks out there. Dead cats they've had there.
Oh,
It's
Rats.
terrible. Rats.
Cockroaches.
Cockroaches are coming into our yard. We fight with the stuff all the time. It's unbearable.
Okay.
I'm sure the whole neighborhood, the house values have gone down because of that.
And sir, can you put your name on the record?
Yes, Francis L. Brown.
Okay.
I live at the same address.
Yeah. And so you confirm everything that was just
Yes.
said?
Yeah.
Have you had any conversations with Mr. Smith about this?
His son,
Is it just his son?
yes.
And
He
what does he
threatened to
say?
have me arrested for looking over my fence,
Mm.
what he's doing there. People come all hours of the night for whatever reason, I don't know. But I have observed many people come in there with trailer loads of junk. He's running an unlicensed junkyard there, in my opinion.
All right. Is there anything else?
No, he's filled it up now.
The
And then he
backyard
put
is
up a
just
fence so he can't be seen from the street. But it's all full back there. His whole backyard is full of junk. You name it, it's back there.
And of course, the vegetation, the grass is growing up high and is everything. I don't know what the garbage the cats have dug.
I asked him why he's doing all this stuff, and he said, "Stay off my property," which I wasn't
And
on,
it's
and
not
I was
his
on mine.
property, it's not
They
his.
border right next to me, you know, so they got a driveway right next to my kitchen window that they go in and out.
I hear you. Okay.
Did you want to say anything?
I'm Darcy Felty, and I live right across the street, so when I look out my door, open my...
Hey, ma'am, can you speak a little closer into the microphone? Thank you.
I live on 5640, which is right across the street, so like, when I look out my window, I see the festival, you know, and it's been there, I've been there a year, and it doesn't change, you know what I mean, and debris flies.
Yeah, I'm really surprised by some
and
of the debris I saw.
mosquitoes, and-
Yeah.
And it's just, I don't know, I'm just here to reinforce, you know, the fact that, something has to be done.
We were afraid during the hurricane that things would just really
Yeah.
go in the
Yeah,
whole
we all
neighborhood.
cleaned out our yards and everything, because it was supposed to be a really bad hurricane, and
Well,
all
it
that
sounds
was
like
still
there
to
is an immediate health, safety,
Definitely.
sanitary issue. And it might be worse now that Mr. Smith is kind of out of the picture and it's kind of gone to the dogs, so to speak.
Or cats.
All right, is there anything else you'd like to say?
Yeah. Mr. Smith hasn't lived there for some time now.
Because he can.
Yeah,
Yeah.
I understand.
I was provided some photos by the public. If you'd like to see them, I could submit them.
It's up to the county if the county wants to
Sure.
introduce
I-
them.
I
Is
think
that-
it- I think it helps to paint a
Okay.
picture.
It's what we see from our window.
I would love to
This-
see more. It may impact how we rule here.
It's from the window of our home, and it's what we see every day. It's
Hold on,
worse.
who took this photograph?
Pardon?
Who took this photograph?
I didn't.
Okay. There's handwriting on this photograph. What is the handwriting?
I wrote it that that's where it was, and that's taken from our southern windows in the kitchen and the family room where I took the pictures from.
And who took this photograph?
Same one, same.
You did?
Yeah.
Okay. And the same handwriting, this is your address?
Yes.
No objection to the photographs.
Okay. Then we'll admit them as Exhibit C. No, D, Exhibit D. Let me take a look here.
And this is why we'd ask that you make Mr. Smith, if he comes into compliance, to allow us into the backyard to make sure that the rest of the junk and debris is cleaned up as well.
I'll certainly so find. What's the county's recommendation?
Certainly. Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day along with the administrative cost to begin on the date of the posting of the property, which was October 30th, 2024, and continue until December 17th, 2024. This would be a total of 48 days at a rate of $150 per day, totaling $7,200. We'd also ask that the special master impose a fine of $300 per day from this day forward until the violation is abated. This amount was selected based on the actions of the property owner once he was advised of the violation, and it's appropriate given the severity of the violation and the respondent's actions relative to the violation. We'd also ask the Special Master find it's respondent's responsibility to contact the Code Compliance Division, allow us to have access to the backyard to inspect once the violation has been abated in order to allow for reinspection.
All right, I'll adopt the county's proposed findings as to the amount up to December 17th. In other words, from October 30th to December 17th, 48 days, $7,200. It's true that in Exhibit C, the prior case, it was $50 a day. And so going up to $150 for that portion makes sense. However, based on the representations about the rats, the health, safety issues, it's going to be $500 a day from today's date forward until it abates. That's an example where it sounds like it's a danger to the people who live there as well as the neighbors. And that's really most that I can do. There's not a lot else that I can do. So that's it.
Great, thank you, sir.
All right, thank you.
Next case, Donna A. Veal, case number 2024-1626, Code Officer Julie Wilkinson, page 42 of your agenda.
Sir,
Hey,
do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
yes, ma'am.
Please state your name.
My name's Leland Nichols.
Thank you, sir.
And sir, are you an owner of the property or a tenant?
Yes, it's me, my brother, and my sister.
Okay. Is Donna Veal a sister?
That's my mom. She passed away like 3 years ago.
I got you. Okay. All right, thank you. And are you contesting whether there's a violation on the property?
No.
How much time do you need to bring it into compliance?
Like 60 days maybe. I got most of it cleaned up except for the logs in the front yard.
I mean, the only thing I see here is it's grass, weeds, brush, and undergrowth in excess of 18 inches.
Yeah, I got most of it. I got it all knocked down except for just some big logs in the front yard.
Logs? I mean,
Yeah.
From the,
For, under the code for the overgrown lawn, it includes like accumulation of the vegetative matter, so that's why I have the logs under there.
oh, I see.
Mm-hmm. And it is just the logs at this point.
I see. How big is the property?
0.76 acres.
There must be a lot of logs if it would take 2 months to.
there's like 20 logs, but they're like this big around that somebody dropped off. I don't know who, but I ain't been able to get the chainsaw and stuff.
All right, can I see the photos?
Yeah.
Do you have any objection to these being evidence?
No, sir.
Okay. Let me just take a look. Is there anyone from the public who wants to be heard on this case? All right, let me just take a look. Thank you. Oh, I see. I didn't see it in the first few photos, but now I do see it. What's the county's recommendation?
$100 a day.
Okay, you've got 2 months, and if it's not brought into compliance as ordered, $100 a day.
Yes,
All
sir.
right.
Yes, sir.
Thank you.
Thank you.
Thank you.
Okay. Next case on the agenda, David Lynn Wilson, case number 2024-00228, Code Officer Julie Wilkinson, page 43 of your agenda.
The problem with being a W, whether it's a Wilson or a Waugh.
At the end, I know.
I'm always at the end of the lunch line, and by the end I get there, the chocolate milks are gone, so
This is on Michigan, correct?
Yeah, he was sworn in.
Do you have some other ones? All I've gotten a certified mail or any mail on is Michigan, but I've heard I got other
Well,
ones.
sir, here's what I'll tell you. First of all, just a reminder, you've already been sworn in.
Yes,
okay,
sir.
so you're still under oath. And Which is this case? This is 43, correct?
This is 00228.
Oh, 228. All right.
45.
Oh, 45, okay. And, so I'm gonna let the county present are you contesting whether there's a violation?
Which address is it?
This is 9 Michigan Street.
Yes.
Okay,
yes.
all right, then let's hear what the
I hadn't
county has to
I hadn't
say.
seen anything, so.
That's fine, let's hear what the county has to say.
Julie Wilkinson, Citrus County Code Compliance Officer. This is a repeat violation. Excuse me. Initially observed on September 19th, 2024. The address of the violation is 9 Michigan Street, Beverly Hills, Florida. Case number 2024-00228. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The property owner is David Lynn Wilson, who has previously been found guilty of the same violation at 11807 West Bayshore Drive in Crystal River on December 26, 2023. That case number is CE 2023-01046 with $7,782 in imposed fines. That case was abated on April 16th, 2024. I have good service via posting on the property and posting at the Lecanto Government Building and signed certified mail return receipt of the continuance letter. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, the findings of fact and the order. The findings of fact, the order imposing fine, and the order acknowledging compliance from the previous case, CE 2023-01046. Exhibit B, photos taken during an initial inspection on September 19th, 2024, and photos I took during my subsequent inspections on October 4th, 18th, 24th, 31st, November 13th, 18th, 21st, 27th, December 4th, 11th, and my final inspection on December 17th, 2024. Exhibit C, a copy of the repeat notice of violation and hearing sent to David Lynn Wilson, a photo of the notice of violation and hearing posted on at the property, a copy of the general pre-hearing order, a copy of the posting affidavit, and a copy of the continuance letter, and a copy of the signed certified mail return receipt.
Okay, first, before we get I'm curious, is the number of photos and inspections because the property is going in and out of compliance?
No, I was just doing like inspections every week, just to make sure, to make sure if the property came out of compliance or went back in compliance.
And I'm just asking, because I'm curious, this started on September 19th.
Yes.
So why is it only being brought now?
Well, in October it was continued because we had the hurricanes.
Right, that's right.
And then in November it got continued because I had a death in the family.
Okay, you were unavailable.
Yes.
All right, then I forgot October. Do you need a minute?
No.
I want you to take your time. I mean, this goes for anybody.
I apologize.
No, there's nothing to apologize for. So, Mr. Wilson, what I'd like to ask you to do is look through these documents. I'm definitely going to want to hear what your perspective is. But before I get to that, the first thing I need to know is, do you have any objection to these documents being evidence in the hearing?
Yes, I do, actually.
Okay.
And the objection would be, all I have gotten is one certified mail signed, I think, last week. Okay? And that was this property. That's how I had gotten from the renter, had told me way back in September, that she gotten it again. She keeps a nice yard. It's never junk, it's never debris. I'm sorry. The day of your first visit, she had one garbage bag sitting by the car fresh. She just sat down.
Well, we'll get into the merits of it, but I first need to really hear their case before I get into the merits.
Oh, I'm sorry.
So what I want to talk about is just these documents. So, for example, in the photos, do you have any reason to believe that those are not authentic documents? Those are
This right
Exhibit
here,
B.
young lady? Okay. Yep, that's her yard, which looks fine.
Okay,
Looks
so you don't
fine.
have any objection to them being evidence, you have commentary and defenses.
Sure, I
Okay.
understand, okay.
Now, on Exhibit A, do you have any objection to the records about the prior case?
Yes, I didn't know about it at all.
Okay.
I didn't know I owed $7,000. When was that? You know?
So you weren't aware that there was a case on 11807 West Bay Shore?
At April 16th or thereabouts.
Yeah.
I had a case going on. Young Mr. Cody there was the,
It was brought into
guy.
compliance.
What?
You brought it into compliance.
Okay, yeah, that case, but I got fined $7,000 for
That's what I'm
walking.
talking about.
Yeah. I don't,
Well, look.
yeah, I don't
so
know
you-
anything about it. I
so-
don't
so-
know.
So you don't have any knowledge of the documents in Exhibit A?
I remember talking to Cody during the middle of it,
Uh-huh.
young Mr. Cody, and he'll know I'm telling the truth. I said, do I have a court case or something today? And that was sometime during when you was investigating the other one. And he told me, no, you ain't got anything, I ain't got anything. I said, oh, okay, because I thought maybe I gotten something from some old case I didn't even know about.
Mhm.
I think that might have been the hurricane the year before. I don't
Mm.
know. You know,
Well, the issue is.
and I got fined $7,000. I'd have been in court if I knew I had to be in court April 16th. I
Well,
didn't know nothing about it.
this isn't court, and I'm not
Yeah.
good enough to be a judge.
I mean, I'm talking about court, I mean,
Um,
here, I'm sorry.
Yeah, yeah.
It's-
So we have Exhibits A, B, and C. We've talked
keep
about
it-
Exhibit A, we've talked about Exhibit B,
That's
and
it.
then Exhibit C.
We're talking about in Michigan, yeah, okay.
And then talking about Exhibit C, there's notice of violation, notice of hearing, and what you're saying is.
Not getting these
The only
notices.
thing you have actually received is a certified mail a week ago.
Well, last week was the last one to know to come to court, here to
Okay.
court.
Okay.
And that's it. What I have a problem, I already talked to the postmaster there.
Mhm.
I had renters' checks get stolen or not being delivered or whatever. I've had a really bad problem, hard problem with it.
But you are here.
I'm
today,
here, yeah,
correct?
Because
All right.
last week she called my housekeeper who's out in the van, I guess. I got me a little nanny because I got 3 teenage girls I'm taking care of. My wife died, and that's her.
No, again, I mean, really, I'm not trying to rush anybody.
Yeah.
Clearly. Thank you.
My wife died, and her kids, adult children, are a mess. And I have 3 step-grandchildren. One just graduated, got 1 more, and, well, I got 2 more at the house there right now. And they're my step-grandchildren, so I have custody.
In Michigan?
No,
Oh.
at Bay Shore there.
Oh, at
so-
Bay Shore, okay.
Anyway, and then DCF had placed their older sister with me back in the back during when all this was going on. I had another one in the Florida room. Well, she's a drug addict. Now she's finally in jail, but we tried to help her.
Mhm.
But meanwhile, they were evidently stealing a bunch of my mail, or rent checks. But that being said, our post lady is terrible too. She don't want to come up 12 feet of stairs, I guess, to get the signature. So she tells them it was delivered, and sometimes I don't even have it at all. You know, so.
Well,
I got a mail problem. Of course, I can't prove it.
Here's what I'm gonna do.
except that,
First I wanna know if there is anyone from the public who wants to be heard on this case. Now, I don't see anybody or hear anybody. Did I miss anyone? Okay. I'm going to admit Exhibits A, B, and C
Sure.
as evidence.
Yes, sir.
I'm going to want to hear what Mr. Wilson has to say about them.
Yes.
But I do find that they're
Yeah, they're evidence of stories
competent,
and details.
substantial evidence.
Yeah.
So let me get to that.
Yeah, I haven't met this young lady, sir, before. This is the first time. My home I built in 2001, sir, on Bay Shore. But Michigan is a good renter. If you'll see from the picture, the grass is cut and everything, but evidently they leave a bucket or a bag out every once in a while here and there on the side of the building. I don't know. And I think she came a couple of days ago and said something about a pot inside a screen porch in the back, sitting on a shelf. Come on, you
Well,
know.
that probably won't be a violation, but I don't know.
According to the person, whoever came out, that she told my renter it was. And then on the front porch, the day of the first thing, because I'm back to that, it was a fresh garbage bag. She just sat down doing something else.
Well,
And
I
on
don't,
the
I don't
front
wanna,
porch-
I don't wanna hear about the other stuff. I really just wanna talk about this,
This is not
Michigan.
That's what we're talking about.
Oh, okay, okay. Well, but let me, now that we've admitted this in evidence, let me just look back at, because this was, one of my cases.
We did before with the bushes, last year, so we ended up cutting bushes that have been there for decades, back, all the way to they're ugly now. We went and cut them out. They were nice, kinda like a
Okay,
fence.
thank you. All right,
And,
now,
she keeps a nice yard. There's a couple little things here and there, sometimes a couple buckets. I didn't know you even know that a couple 5-gallon buckets sitting against the house are a violation. You know, empty, nothing in them. It's just things, nobody would think that. I would think offhand unless you knew that had to be a violation. She keeps a nice yard. I've never had a problem with it. I ran her about 8 years, I think. And, the front porch, that day of violation, boxes on the front porch, on the screen front porch, sitting behind the screen with boxes. They were full of Boy Scout donations, waiting to be picked up. You know, it's just stuff that shouldn't have been a violation at all. And I think we ought to have something on policy or somehow, some way, maybe the renters can give y'all a number. It'd be nice for me to get a phone call when I talk to you and you'll know what the story is. Because I'm all for having a nice home and stuff like that. But, once a week might be a little much, that's all. Anytime any of us could have a bucket or a garbage bag or something sitting outside for a second, they come in, that's a violation.
well, I'll tell you, the garbage bag wasn't out there for just a day, according to the photos.
Well, different ones, I don't know.
It was-
She told me it wasn't, but who knows? It's a
Weeks.
rental.
Well, I mean, you can see the photos, but I mean, it was out there for weeks.
Yeah, I've never seen those before, so I don't know.
All right.
She doesn't keep what you call a messy yard. It looks decent and neat, most of the trim.
On the scale of 1 to 10, when I get junk, I call them junk cases.
Yeah.
On the scale of 1 to 10.
Yeah.
If all of them were violations, we've had a couple 7s today.
Yeah.
We've had a couple 5s. This is,
Are all these the same day?
I think this is a 2.5.
Are these all the
But it's a
same-
violation.
Are these the same day?
What do you mean?
All these pictures, are they the same?
No, they're not all the same day.
Okay.
This is a well
If I wrote it up there right
chronicled.
now with you, it looks like a nice yard and backyard. I can't went by there this morning.
Well, most of it does look fine,
Yeah.
actually.
Yeah, it's
It looks
probably
like it's
smart.
landscaped. It looks.
Yeah, she keeps the landscape edged and mowed and not on it.
Here's the thing.
Yeah.
Even though some of this stuff is behind a screen, it's visible from the street.
Like the boxes, yeah.
Okay.
And
Now,
I
I'm
guess-
not finding that the bike is junk. I'm not saying that, but the bags that are there for longer than 24, or actually, is it 48 hours?
48.
48
Where
hours.
were the bags? Were they on the side or the front or?
I'll tell you, there's a black bag that was there from September 19th.
She had one by her car. That probably wasn't the one she was talking about.
So let's see, from September 19th, at
Right
least
about
through October 24th, at least through, I mean, and there's other debris. I mean, look, it's,
Yeah,
you're
I
right, Mr.
understand.
Wilson, it's not the case of the century, but it is.
Knowing my renter, I would say that the black bags, I saw one picture right there that looks like it's over on the side of the house or something maybe. Maybe she didn't know that's a violation, but when I had to talk with her, I said, looks like anything sitting outside, period, is out a violation unless it's a car or a bicycle or a tagged truck.
I mean, there's a lot of stuff in the porch that
What's that?
is.
Yes.
Now, the
I've already got
vegetative
them
matter,
open
the
up.
vegetative matter as well.
Yeah. Pardon me?
The vegetative matter, it's, I
Oh, the
wouldn't,
big tree.
I hesitate to call it
Storm.
logs, but yeah.
Storm knocked it down. I did not even know now today, right now, that until just now, from what I gather in what you're saying, the big tree gets knocked down by lightning. You can't wait for it to get a little bit lighter sitting there in the yard and rot a little bit,
No,
and then take it off. Called 4 different tree companies. They're all so backed up, it's not fun.
That is true.
And
I
just
know
couldn't get it done for months. I said, well, we'll let it sit a little bit, and I'm an old man, I can't saw it in half, so, I used to, but I can't no more. I'm also fighting cancer at the moment, and just found out I got diabetes too.
Mr. Wilson, let me ask you
but
this. I'm satisfied personally that there is a violation.
Yes, sir.
It's not a huge one.
Yeah, there is.
Frankly, it can be
Always.
fixed very quickly.
I didn't know you couldn't do the phones.
Yeah.
She sent me pictures, it's nice and clean and neat today, but, no.
And that
Thank you.
it doesn't sound like that vegetative matter's been removed.
No, the tree has not been
So-
removed.
so how much
Now
time
that
do
I
you-
know that's a violation.
How
which I
much
did
time
not
do you
know.
think you need?
Give me a month, I can find somebody can get it out of there. I
Well,
guess.
actually, I'm sorry, this is a
Can I?
repeat case, so here's
So
the
I can't get a
situation.
month, okay.
Here's the problem. With a repeat violation, and it's being brought as a repeat,
I've got,
for every day that it's in violation,
okay, I've got 14 rentals.
Yeah.
Also, I don't even hear about the violations and what they are till, whenever, a month or two later. This particular one, I didn't know we were still in home violation for the case, because when I went by the house, when she told me the violation, I went over. It all looked good that day, that don't mean it didn't. 3 days later, I don't know.
okay.
And that's all I can go by because I don't live there except to check it. But I didn't even know. That was something I said earlier too. We need to know what the violation is and what's wrong, what's a violation, what isn't. I didn't know that tree was till just now.
What is the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 per day, along with the administrative costs begin on the day of the posting of the property, September 19th, 2024, and continue until October 3rd, 2024, and begin again on October 18th, 2024, and continue until December 17th, 2024. That would be 77 days at $150 per day, totaling $11,550, and a fine of $250 per day from this day forward until the violation is abated.
So from September 19th to October 3rd, and from October 18th to December 17th, I'm gonna assess a fine of $50 a day.
So it's still in violation then? It's-
I
it
don't,
sounds something like
I don't know what that works out to, but that's what will be up till today. Now, from today's date going forward, it is gonna be $250 a day, so.
Okay, and so I just found out that that tree's in violation.
Yeah, and so the second that it's brought into
No,
compliance,
the physical.
then you need to let the county know so that this thing stops.
So would not that fine, if you haven't been told it's in violation till just now, how could you be fined for all the days back
Well, that's the
when?
point, you gotta keep it in compliance so this never happens.
Well,
As a repeat.
Yeah, I have never, well, no, repeat on the tree?
And here's the,
Is it repeat on the tree, sir? Or is it just repeat on the whole?
no,
property?
it was a prior case on another address, but
Oh, yeah.
it is a,
14 rentals,
under the code, this is a repeat
I
violation.
understand. So in other words, even if we don't know about it, it's still, yeah, I got you.
Nowadays it is.
Yeah, I know. I strongly think that's very unfair. I really think y'all should get a hold of the owner themselves, not the renter. They're not always gonna tell you. Especially if they're behind a rent, they don't call you at all. This is a good renter, so she did call me, but still, she called me a week and a half after.
Well, you may wanna put it into your lease that if you ever get a fine, they have to pay it. I mean,
Yeah.
it's just something to think
Then we
about.
have chapter 83 to deal with. You can't necessarily just throw them out quickly.
That is
They
the
have
truth.
more
That is the
time than
truth.
y'all would like to give me to,
That's how chapter
render.
83 works. You're right about that. All right, so that's this case, but I think we
do have another case
We have
for
another-
Mr. Wilson as well.
Thank you.
I got Bay Shore also.
Next
Well,
case,
is there a
David
way for me
Lynn.
to find out if I have some other cases?
We
out
can,
there I
we
get
can,
fined?
we can get together after the hearing and we'll go over all your cases and your properties.
I'm not getting them.
Just-
Mr. Wilson, we'll talk about it. I just want to get to your next hearing.
David, next case, David Lynn Wilson, case number 2024-00228, Code Officer Julie Wilkinson, page, did I go to the wrong? I apologize. Code Officer Erica Wilson, page Olson, I'm sorry, excuse me. Page 45 of your agenda. Wow, sorry.
Which address is this?
This is on-
Oh, okay.
7578 West Carmack.
Okay, yeah, they're getting evicted. They got a notice to be evicted already. take it to the courts. 'Cause-
Really?
They're not living there, but they got dogs in the trailer, and grass is all grown up. And she says she's living there, I said, well, then fix it. Well, no, she said, well, we ain't got any power or water. I, what?
I'd like to let the county present the case
So,
first.
I'm sorry,
Go ahead.
No worries. Erica Olson, Citrus County Code Compliance Officer. Again, this is case number CE 20241875, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20, Tax 60 of the Citrus County Code of Ordinances. The address is 7578 West Carmack Court. Property owner is David Lynn Wilson. I have good service via signed certified mail return receipt. This property is approximately 1.01 acres and is zoned Coastal Lakes Residential Mobile Home Allowed. At this time, I'd like to authenticate the following documents.
0.01 acres?
One-
No, it's
1.01.
Oh, I'm sorry.
Did I
Okay,
say
okay.
0.01?
No, I don't know. I probably heard it wrong.
This is just, I didn't get.
I'm very hungry, so
Just
it's
start
very
finding out
possible.
why,
that I-
I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on October 24th, 2024, my corrective action inspection on November 4th, 2024, and photos of my final inspection conducted yesterday, December 17th of 2024. Exhibit B, a copy of the notice of violation, notice of hearing, copy of the pre-hearing order, and a copy of the certified mail return receipt.
All right, sir, same deal. Let me know
Yes,
if you
sir.
have any legal objections to these documents.
Well, I don't know if it's a legal objection or not. I got no certified mail. The post lady did not, it didn't happen. She lied.
Then I'll take a look at it.
So, I mean, I wouldn't even know, I don't know nothing about this except I'm evicting these people for this.
Okay.
That's all. Yeah, well, there's nothing y'all can do about it. Y'all didn't know what she lies. It's constant.
Is there anyone from the public who wants to be heard on this case? Y'all have definitely turned the temperature down in here. And I like it, by the way. I like it. I'm not sure everyone else does. I've seen people, shivering and.
Yeah, that's what we mean.
Your Honor, may I say?
Yeah.
I think as evidence, it's not evidence unless you got my signature on that certified mail. If you don't have where I signed for that, it's not evidence. And the case, I haven't been informed at all till right now, just a minute. That I even had this right here, this case. It's because the mail lady is not bringing my certified mail to me. She tells the post office she did. The only one we've had signed was the last case right there. Last week, I actually, because somebody was out in the yard, the girl using for a nanny, signed for it. As the one that's here, she's out in the van. But I haven't received any notice from code enforcement on this one till today. It's not her fault or code enforcement's fault. I should be getting fined for something I didn't even get a notice on. But anyway, sorry.
So on page 6 of Exhibit B, there is a signature, but I don't know what the first word of it is.
Can I see it, sir, if it helps any?
Yeah, sure.
I want to see if it's anyone I know, maybe.
Well, it says David Wilson, but I don't know.
Could I sign a piece of paper for you, sir? Just know what it says.
I don't know. What's that first word, do you think?
Postman, right? Is that what?
Our man? Our man?
Who is that? Nobody I know?
Okay, all right.
Our,
I don't know what it says. Thanks.
nobody I know. Unless that's the post lady.
Well, it went to that address. I mean, it went to.
No, she's lying, or she just lost it, or she got behind, I don't know. Except that, like I said, I've been having mail getting stolen, but,
I really don't know what that first word is, which is. it
our
isn't-
man or something. I don't know. Same person.
Well, it's two signatures too.
And it looks like the same person right there.
Why would it say? Or P-man? Postman?
Postman, that's what I thought. And that's the lady.
But why would it say that?
That's a good question.
She's not allowed
you
to,
ever-
she's not allowed to sign for me. She's gotta bring it, 'cause I got 12 feet of stairs, in a beautiful home. You'll see in some other cases. Anyway, and it's 12 feet of stairs up there to my door. And,
All right. Well, you're here, and, you know, the photos, this is a overgrown
This is
lawn
called
case.
it's a catastrophe. I've already.
Tell you what,
I drove
I don't
out
need a
there.
ruler to see that it's over 18 inches.
Yeah, way over. I drove out there and I've taken 2 loads out last week. I just didn't know we had a case on it. But
How much time do you need to bring it into compliance? Or, I'm sorry, is this brought as a repeat?
No, this one is not
Okay.
being brought as.
How much time do you need to bring it into compliance?
Give me a couple weeks. I'll jump on it.
Is 14 days enough?
Yes, please.
What's the county's recommendation?
The Citrus County recommends $100 a day with administrative costs.
And is there anyone from the public who wanted to be heard on this? I forget. Fine. All right. You've got 14 days. Okay. And if it's not brought into compliance as ordered, $100 a day. Is there anything else?
No, what is bringing it under compliance? I don't even know what the charge is.
You gotta get that,
Kinda
growth under 18 inches, so whether it's
Okay.
taking a lawnmower or a machete, as it may be the
Oh,
case.
okay, it's growth. That's what we got. Yeah.
Growth and vegetative matter, yeah.
Vegetative matter, okay, yeah.
And I encourage you to get with the county about whatever other cases.
Yes, I-
Sounds
I
like you
told-
have a lot
Yes.
of, a thriving real estate empire here in Citrus
Well,
County.
I'm getting killed here. I've lived here 21 years. I'm getting killed with this. The mail, I was managing 16 other properties for a company, and I had to let go of that job because my mail getting stolen and, and stuff like that. I can't, told them, I said, that's what I can do, whoever's victimizing.
Well, some of these
me.
properties look nice, so I hope you can work it out, and,
Yes, sir. That one in Michigan's a beautiful place.
I hope you have a happy holidays.
Thank you. Merry
All right.
Christmas to you,
Thank you.
sir.
That's right, we say Merry Christmas here in Citrus County.
Yes, we do.
Next case, Frederick McLaughlin and Tara Pointer, case number 2024-1830, Code Officer Brandon Norman, page 32 of your agenda.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Please state your name.
Tara Pointer.
Thank you.
All right, thank you, ma'am. Are you the last?
Yes.
Oh,
I
my
think
goodness.
so.
Okay.
No,
all
that's
right.
okay, thank you.
Good afternoon, Brendan Norman, Citrus County Co-Compliance Officer. This is for case 2024-01830, accumulation of junk.
I'm sorry, Mr. Norman, Ms. Pointer, are you contesting whether or not there's a violation?
So, no, but yes.
No, but then, okay. Then please proceed.
Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. This is for address 5505 South Calgary Terrace in Inverness, Florida. Property owner listed as Frederick R. McLaughlin and Tara Pointer. Good service via signed certified mail return receipt, and I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during my initial inspection on October 22nd, 2024. A corrective action inspection done on November 13th, 2024, and a final inspection done on December 17th, 2024.
Ma'am, I'd like to ask you to take a look at these documents and let me know if you have any objection to them being evidence.
Sorry, it's a little cold in here.
Yes.
What was the middle date?
It's November 13th, 2024.
Coldest I've ever been in Florida is when I took the Florida bar exam, and in the room, it was so cold.
That room is freezing.
It was when you took it too?
Yeah.
I was chattering. My teeth were literally chattering, and I just got the heck out of there. And I thought for sure I failed. Maybe they swapped the results with someone else. But
I remember the second day I made sure to, I had a hoodie.
Yeah, yeah.
Some people brought blankets.
I did
it
not
was bad.
come prepared. No. Ma'am, did you have any objections?
So, those are the pictures of my house.
Yeah.
When he arrived, he was very specific in what he was there for.
Mm-hmm.
So the surrounding pictures that he has taken
Thank you.
were not a part of our conversation.
Okay.
like, I mean, I can, it'll go, I guess, to the rest of what I have to say, because like, I've called him multiple times, left multiple messages with no phone call back, trying to get clarification as to what more I needed to fix. And because, like I said, he came out for sticks because apparently somebody had called over sticks following the hurricane. And I didn't pick him up as quick as she wanted. I'm not even sure. And when he arrived, my boyfriend had literally just gotten done fixing his truck. So there were tools because he had just drove off the driveway. And then there was appliances there, but
Ma'am,
that's.
I'm just asking about the exhibits. I mean, if you're saying that they are, as far as you can tell, accurate photos. You may not like what's in the photos.
No, absolutely,
but,
I agree, because like, I mean, there's no doubt about the mess, but.
Okay. Do you have any objection to them? And if you do, let me know. But I mean, do you think they're inauthentic or inadmissible for some reason?
No, I mean, like, I believe that they're authentic.
All right, I do too. I'm gonna admit them as evidence, and I don't know what the county is going to present, so what's your case?
Certainly. On October 22nd, 2024, I conducted an inspection for a complaint of junk and debris on the property. I observed the property to be in violation due to discarded items, appliances, and other junk and debris on the property. I did have a conversation with a gentleman outside of the property. He was a little, I don't want to say combative because it wasn't quite that, but he was kind of upset that I was there, especially he mentioned the fact that why I'm not holding the property across the street accountable for the tree and debris that's there. To my recollection, that's the only time we talked about sticks. I explained to him, what items would be in violation. I always tell everyone that if it has an outside purpose, it's allowed to be outside. If its intended use is not for outside uses, it needs to be stored away and stowed properly. I asked the gentleman how much time he needed to come into compliance. He told me 2 weeks. I explained to him that, if he needed more time to let me know. Before I did my corrective action inspection, on the NOV it says November 4th. I did speak to Mr. McLaughlin via telephone. We talked. He told me that he was going to come down, assist in the cleanup of the property, make sure it was taken care of, and ask for additional time. I gave him that, but on November 13th, 2024 is when I inspected the property. It was still in violation. And as of yesterday, during my pre-hearing inspection, it remains in violation. The property is a little long-wise. It's approximately, I have it right here, 0.56 acres. So I can't see the backyard per se as well. So again, this would be one of those situations where, because the actual complaint originated from someone observing the junk and debris in the rear of the yard. So I would just ask that, you just have the property owners allow us to have access to make sure the entire property is in compliance after the date that you deem.
If I find there's a violation.
If you find that there's a violation.
Okay. I'm just gonna look through the photos here. I can see where there might be questions about some things,
So.
Yeah, go ahead.
So he came out, and yes, my boyfriend was not quite combative, but I mean, he wasn't the friendliest either. We've been dealing with a lot with the county, I shouldn't say we, he has been, so, however, he did say the 2 weeks. I was like, well, that was kind of dumb. You should ask for more right then and there, but I called that following Monday after the 2 weeks had passed. I called and did actually speak to him and request additional time. He granted it. I was not aware that he was calling my stepdad, because my stepdad is the one who's on the property as well. Was not aware of these phone calls. I have personally called and left 3 different messages to talk to him. One time I did talk to somebody who transferred me, stating he was out that day and would return my phone call probably the next day. But out of all 3 of those phone calls, I have not gotten a phone call back. I want to be in compliance. I'm not here to cause trouble. Like, I've got nosy neighbor right here beside me that blames me for dirt in her pool with a pool screen, like trees, pollen trees. So it, you know, like she's just, whatever. I just needed, like, I wanted further clarification as to what, because like I said, during that initial coming out there, what was mentioned was the garage area and the front yard and the driveway. Nothing about the side yards, nothing about the backyards, nothing about anything. I'm not contesting that it needs cleaned up. I'm not disputing that fact. What I'm disputing is the fact that I'm now here having to explain this because I've not been able to have a conversation with him to get further, you know, either requesting additional time to prevent this or to find out exactly what he's looking for.
Okay.
I did have to go to DC the week before Thanksgiving because my son sees a medical specialty team up there. And I called the Thursday that I got back from that. I mean, I was calling weekly prior to try to contact him.
All right, Mr. Norman, what remains to be done?
On the photos.
That you can see.
Yeah, so on the photos, there are some just miscellaneous stuff that are in the front of the area that need to be stowed properly. The concern that I have is on, if you're facing the property on the right side, there's a bunch of like tarps and storage containers and stuff of that sort that need to be stored properly. And I'm just not sure, because I haven't seen the back of the property, right? I've only done my inspections from the roadway.
Well, let's be clear though. So just to start clarifying some of this stuff, for example, the toys.
If it's an outside toy, certainly it can
Exactly.
remain outside.
So like I see an outdoor, it appears to be like a house, not a violation.
Not a violation.
Right.
The items that surround it, though, that do not have an outside purpose would be a violation.
And I see, what's stored on the trampoline?
Children's toys.
Yeah.
I mean, I have 6 kids total. I mean, 4 still at home, and
Yeah.
all of them 9. I have 2 9-year-olds, a 12-year-old, and a 6-year-old. So they're, you know, they've got lots of stuff.
I don't even know what the blue thing is on the ground in the backyard. It's
That was probably the remnants of a pool that has been since picked up
Okay.
and discarded properly. But
okay. I mean, this was from yesterday. So I mean.
then maybe it's not that. What I'm
Yeah,
thinking.
I don't know. Yeah. Like right over here. It's behind the kid.
It might be
House.
the vehicle that's no longer working. I'm not positive.
I mean, there's a bunch of stuff like in it.
I know he had like some wood pieces in it, like kind of being used as a storage thing.
I mean, that's junk. You know.
You're not telling me I haven't already said, but like I said,
We want clarification. I mean, I think
Well,
that's really obvious.
and you know, like, and I'm not being rude, but it's, you know, my yard. I'm not in the city limits for a reason. I get it. I've got nosy neighbor right here that wants to like cause trouble because that's just what she does. I don't have a problem bringing my stuff into complaint. I just need to know. I
don't want to be rude either, but guess what? Have
Yeah.
you memorized this? This is yours. It's
Which-
yours. And I mean, look, they. I think this is easier than it seems. There is a lot of loose kind of debris. It just needs to be stored. I mean, it needs to be stored or discarded appropriately. There's some things that are allowed to be outside. I mean, if you have like a bucket that you're using for planting or like a potter, that can be outside. It's not junk because it's used for what it's meant to be used for. But when stuff is strewn off its side, not used or discarded, frankly, whether it was used by a kid or not, it's a violation under the statute. And
Which I get that. My question comes into the fact that during the initial conversation, All that was talked about was the front yard.
And that's irrelevant, and I'll explain why. So let's say that he goes to the front yard and all he sees is something in the driveway. It doesn't mean that you're released from complying with the stuff in the backyard.
I'm not saying that.
Okay.
I'm not saying that at all. My, like I said, that was our conversation. I've
Right.
called multiple times to get clarification. It's not hard to return a phone call, but yet he's telling me he's returning a phone call to my stepdad.
Well, most
But
of
I just needed the
I
phone
make
call.
every effort to return phone calls.
Well, most of what I'm hearing, this is what I'm hearing, is it's not really arguing about the violation, which is what I would expect. You're arguing about how well he did his job and getting back to you. That's what I'm hearing.
I just wanted clarification so I could have prevented this. Because this, and no offense and to anybody, I work hard.
Yeah.
I have, kids that I'm supporting, and I'm using a day of work to be here. And I just wanted to prevent this.
Okay.
Because I will do whatever it takes.
Then let's
to get
prevent
it
you coming
fixed.
back. How much time do you need?
Can I get 6 weeks? Because if you're asking for the backyard and to be able to get everything out of there, because like I said, I gotta find somebody to remove that vehicle. I gotta find somebody to, do a hot minute of a few things back there, to be able to
All right,
fully
what's the county's
satisfy.
recommendation?
Certainly. Citrus County Code Compliance Division respectfully requests the special master assess a fine of $100 per day along with administrative costs to begin after the date that you deem sufficient to abate this violation. It will select it based on the actions of the property owner. And once they revise the violation and as appropriate given the severity of the violation as well as their actions relative to the violation. We'd also ask the special master to allow us to have access to the backyard with the property owner in order to verify that the violation has been abated once it's ready to be inspected.
45 days as requested, and $100 a day if it's not brought into compliance as ordered, and also order the inspection requirement.
Thank you.
Okay, thank you.
Next case, excuse me, Lindsay Marie Rumens, case number 2024-1779, Code Officer Alan Jonason, page 34 of your agenda. Expert on the case, Land Development Director Joanna Katu.
Let's talk about this for a second. So how many more cases? We have 1, 2, 3, 4. How many?
Yeah, I mean, let's see.
I'm really surprised at how long these took. Of course, I didn't help with the traffic, but 1, 2.
So we got roughly, 19 cases left.
Are the hallways presented together?
No.
Oh, two, they're split into two?
Yeah.
Okay.
Because they're different, yeah, they're different, different
1, 2, 3,
properties.
4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17. I mean, I'm just thinking about how long. Well, we're gonna break for lunch. I've just gotta eat. Now, I don't think we need to break for too long, but how fast can you do a lunch?
I'm just concerned that we may not have the room.
Oh, when does it
Somebody
end?
else- somebody
2?
else may have the
Is it
room.
end over at 2?
I don't know. I'm
Can we
gonna go
check
find
your
out.
We can
cat?
find
Yeah,
out.
yeah, if we can.
Okay.
Oh, I mean, look, my plan would be to do a very quick lunch. It's just, I can't keep going for an hour. My suspicion is it'll take about an hour, but,
Yep. Can I make a suggestion?
yeah, please.
Can we get through Joanna's last 2 cases?
Yeah,
Yeah, before we-
okay,
she
yeah,
only
I
has
think
3.
that's
Get it
fair,
all
that's
away.
fair. Let's do that.
That way you don't have to come back.
Yeah,
You're
let's bring
welcome.
those. No, I mean, that's fair, that's fair.
Thank you, good job, come forward. Thank you.
I'm hungry too. These will be quick, Joanna.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2024-01779. Citrus County Land Development Code, Section 4002, site development without a development order or permit. Address is 6790 North Hartman Path, Hernando, Florida. Property owner is Rumens Lindsay Marie. This property is 3.79 acres and is zoned CLRMH. and was purchased on 18 June 2024. I have good service via signed certified mail receipt and posting at the Lecanto Government Building. Would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on, 15 October 2024. Photos from my compliance inspection on 17 December 2024, and an aerial photo from the property appraiser's website from 6 May 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the signed certified mail receipt, a copy of the pre-hearing order, and a copy of the property appraiser.
Is there anyone from the public who wants to be heard on this case? Okay, I don't think there's even anyone from the public left. Then I'll admit exhibits A and B as evidence.
On 15 October 2024, I conducted my initial inspection and observed the property to be in violation. On 31 October 2024, a notice of violation was issued for site development without a development order or permit, which is a violation of the ordinance mentioned earlier. On 14 November 2024, I conducted research with no permits issued, and as of my final inspection on 17 December 2024, the property remains in violation, and I have not had contact with the property owner. Joanna Catu from Land Development.
Yeah, just real quick, they actually have applied for a building permit. They did it end of October. It was not approved. They waited until December 11th to resubmit, still denied, so they have a permit application, but not a permit.
Do you know how far away they are?
Stormwater completely did a denial, so that's gonna be a little bit of work. But
Wow.
otherwise, everyone else looks like they're okay with it now.
Oh, okay. County recommendation?
One-time fine of $5,000.
We'll do 1,500 for this one, and that'll be that.
Thank you.
It's Christmas.
Next case, Kenneth W. Pressgrove Jr., case number 2024-1861. Code Officer Erica Olson, page 33 of your agenda.
When I was a prosecutor on misdemeanors many years ago, there were Christmas pardons for certain nonviolent offenses, but
People in the zoning board, one lady always says, "It's the Christmas season, give it to me."
well, for the Darmientos, I don't know what they celebrate. I'm really intrigued. I'd like to learn more, so. Anyways, go ahead.
Eric Olson, Citrus County Code Compliance Officer, case number, this is Presco, okay, CE 202401861. Special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102 Alpha. Address is 7254 West Haddon Otter Lane. Property owner is Kenneth Pressgrove Jr. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. Property is listed as vacant. It's 0.47 acres and is zoned medium density residential. I'd like to authenticate the following documents and request they be admitted into evidence. Photos taken during my initial inspection on October 22nd, 2024. Photos taken during a corrective action inspection November 6th, 2024, and photos of my final inspection conducted yesterday, December 17th, 2024. Exhibit B, a copy of the notice of violation, notice of hearing posted on the property, a photo, and a copy of the posting affidavit, and a copy of the pre-hearing order.
Okay.
On October 22nd, what am I doing? I'm sorry.
Yeah, I don't think there's any objections, so we'll admit those as evidence. Thank you. Go ahead.
On October 22nd, 2024, I conducted an initial inspection and found the property to be in violation. The property is listed as vacant and there's an RV parked in front of the property with garbage around it. There's also some garbage and miscellaneous items around the RV. NOV was issued October 23rd, 2024. On November 6th, 2024, a corrective action inspection was conducted and I found the property to remain in violation. In addition to the RV, there is now more garbage, a tent, and a vehicle for that inspection. Yesterday, on December 17th, I conducted my pre-hearing inspection and found that the property remained in violation. And there was an even larger pile of garbage during my inspection yesterday.
Okay. What's the county's recommendation?
So I actually am just recommending the $50 fine per day along with administrative costs.
Okay. Then we'll do.
No, I don't think it's There are people like living
I'll
on
do
that lot.
wait, I'm
so-
sorry?
Oh, I was explaining to Joanna, sorry. Go ahead.
There's people,
They're like staying in that RV, yeah.
I mean, how are they disposing of?
They're just kind of dumping their stuff. Like, it looks like they're just opening the door of the RV and just.
You know they're doing that?
I haven't seen it, but I'm fairly certain. I did try and issue a citation,
Okay.
but that individual, he wasn't there. So, I mean, we
Okay.
went out, was it last week with the sheriff's
Do we know if
department?
the people who are there are the owners?
So I actually, they are the people that were living next door
Really?
that were evicted, and that case abated yesterday. It was supposed to come to you, but it ended up abating. So they got evicted next door and just
I
moved
hate
an RV.
to punish an owner.
And that's why I recommended only $50.
No, that makes perfect sense. Well, no contact with the owner?
No, sir.
Okay. Well, I'll do 30 days and $50 a day.
Thank you.
Okay?
Next case, well, no, we got one more for Joanna.
We have one.
Yeah, I was
Yeah.
told to, but I see another one. All right.
Next case, Laura Jo Harris and John P. Casquay. Case number 2024-1834. Code Officer Cody McGuire. Page 21 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Yeah, thank you.
All right. Cody McGuire, Citrus County Code Compliance Officer. Case number 2024-01834. Use standards 3102E, special requirements for all accessory uses. Address is 6397 West Stockholm Lane in Dunellen. Zoned RUR-MH, and it's 2.48 acres. Property owner is Laura Josie Harris and John P. Custagonway. Sorry. Good service via posting the property and posting at the Canto Government Building. I would like to authenticate the following documents and request they be admitted in evidence. Exhibit A, photos taken during initial inspection on October 21st, 2024. Photos taken during a corrective action inspection on November 13th, 2024. And photos of my final inspection on December 17th, 2024. And Exhibit B is going to be a copy of the notice of violation, copy of the notice of hearing, copy of the posting affidavit, and a photo of the notice of hearing posted on the property and a pre-hearing order.
Okay.
Take a breath.
Thank you.
Man, that was, yeah, take a
Without
breath.
objection, what's been proposed as Exhibits A and B are evidence. Go ahead.
Go ahead. All right. So on October 21st, 2024, I conducted initial inspection and observed the shipping container to the right of the house past the driveway. On November 13th, 2024, a corrective action inspection was conducted with no change or no permit issued, and my final inspection on December 17th revealed the same thing. I have had contact with property owner Laura. She said she was going to be here today, but
Okay. I have a question. So it seems as though, if I'm reading this code, does Citrus County not allow shipping containers to be used as storage anywhere?
Correct, for residential, yes.
Okay. Oh, I see. All right, that makes sense. What's the county's recommendation?
$100 a day.
Is this the only issue?
Correct.
Like, okay.
I had an unlicensed one, but that abated yesterday as well.
All right, I'll do 30 days and $100 a day.
Thank you.
Thank you. Let's just come back at 2:20. Thank you.